in it are members only. So I wouldn't want to entertain any other person except the members. It's a committee meeting. So I just want to indicate that I see you've raised your hand. I cannot take it. You'll have to find another way if you need to communicate with the chair. It is a committee meeting. I'm only allowing members to participate in the meeting.
Not members, Chairperson. I've written you an agent letter.
I will look at that letter. Thank you.
And it's not for you only, it's for the committee. And evidence leaders are not members.
I did not give you platform, just mute here. You're not going to repeat that. Okay. This is a meeting of the committee.
I've sent you a letter.
You are not a member unless you are.
But the evidence leaders are not members.
Just mute her. Just mute her. It's a committee meeting. You're completely out of order. And I'm not going to take that attitude from you. Thank you.
I'll release the letter.
We now proceed. Over to you, Advocate Bauer.
Good morning, Chair. Good morning to the members and the public. Chair, we will proceed on your instructions in addressing the committee. And I want to pick up where I turned to yesterday. I had taken you through substantially the affidavits of as it appears in the CR17 matter, and what I had asked you to bear in mind was the date of the affidavit deposed by the public protector on the 14th of November 2019, being the answering affidavit in the CR17 matter. And where I ended it off yesterday was to say to you, I want to take you to the affidavit that the public protector then deposes to 2 days later in the Gordhan SARS unit matter relating to the SARS unit Gordhan EMEA complaint. So you will recall, and for those who may not have had a chance to listen to last week yet, that the report that had been issued on 5 July 2019 included an EMEA complaint as well, and hence I'm going to that so that in one go I can endeavor to finish the EMEA complaint matters. So the issue arises, and you see it from the report, and for ease I'm going to call it the PP Gordhan report dated 5 July 2019, and I want to go to page 39 of that report at paragraph 5.1.11. All right. So the Gordhan report was issued on the 5th of July 2019, and the CR17 report was issued on the 19th of July, 5th of July 2019, and the CR17 report was issued on the 19th of July 2019. And it's the correlation in time periods. I'm waiting for Shepherd to put it up, which is why I'm waiting for you to do that. So we also know from Mr. Mataboge's evidence that he was the only investigator in the CR17 matter, and that he was the chief investigator in the Gordhan matter together with Ms. Mkhwebane. So if we go to paragraph 5.1.11, which would be roughly 16, 49, roughly about 255, I think. Go down, up, sorry. 5.1.11, right. So in the 5.1.11, we see that in this report, paragraph 2.3a of the Executive Ethics Code provides that members of the executive may not intentionally or inadvertently mislead the president. So now we have in this report what we had referred to as the 2007 version of the code. right? And it is in this report that the PP concludes that Minister Gordhan had deliberately misled Parliament in this matter. So in this report, and I want to take you to the answering to the affidavit filed in the litigation, which is bundle E, volume 35, page 2754. Right. This is an affidavit. Go to volume 35. Click on page 2890 first. Okay, so yeah, so go to the it's 2890. It's the last page of the affidavit. Can't go down. Right. The reason why we're on the last page is to show you on what date the affidavit was deposed to. It was deposed on the 16th of November, 2019. So the answering affidavit in this matter is completed 2 days after the answering affidavit in the CR matter. And so if we go to page 2754, I'm sorry. Sorry. Just the I've just so the point being, and we have to just go down, sorry, because your numbers are not corresponding to mine. Just scroll down and I'll find the reference to it quickly. Let me do that on my version of the report. My apologies to the members. We've just had a no, it's not the same as the numbering. So let me just get it for you for a moment. But scroll down. Yeah, I want to just see the finding. Yeah, I don't want to waste time, so I'm going to find this reference during the tea adjournment to show the committee what I'm referring to. The proposition which the paragraph would refer to is to show that the findings in the Gordhan related matter related to the 2007 code, the same code was admitted, whilst the 2000 code was admitted to be the correct one in the CR17 matter, and that the two affidavits were at variance. Because we're actually dealing with the CR17 matter, and I just digress to show that point. But I'll find the reference in the tea adjournment and take you back to it. So if we go back to the we'll go back to the High Court judgment in the CR17 matter, and we want to go to paragraph 58. Yes. Actually, no, just. Paragraph 58. Sorry. So apart from the EMEA code, the court looked at the facts as well, and it then came to the conclusions, and Advocate Mayosi is going to deal with this as we proceed. But I thought, let me just put this into context for you now. In paragraphs 58 onwards in the judgment, it sets out to you what the court had to say in respect of the findings. It is important to appreciate that the president was not asked by Mr. Mayamani to comment on whether the account EFG2 was in fact an account held by Andile, nor was he asked to confirm that the payment on that date was one made to his son. These were given facts that Mr. Mayamani put to him as having already been established, and the president's answer was directed to those facts. Of course, we know with hindsight that the payment was not to Andile and that the account EFG2 was not linked to him. At the time, however, these facts were not known to either Mr. Mayamani or to the president. There is no evidence to indicate that the president knew about the account EFG2 at the time he answered the question, or about the 500,000 donation made by Mr. Watson to the CR17 campaign. The uncontested evidence before the public protector was that the president only found out about the donation and about the account EFG2 after he had answered the question in Parliament. Paragraph 60 says, there's also nothing to gainsay the president's version that he focused on the gist of Mr. Mayamani's question and not on the date of the payment, which was in fact before Andile's agreement with AGO came out, or the account details. Indeed, it is clear that these details were not the thrust of Mr. Mayamani's concern at all. However, if the president gave Parliament incorrect facts, this was based on a misstated set of facts presented to him by Mr. Mayamani in the first place. The origin of this error was on the part of Mr. Mayamani, not the president. In these circumstances, whatever incorrect facts was placed before Parliament, the president cannot rationally be found to have misled the National Assembly in that regard. Paragraph 62 says the evidence supports his version that they acted in good faith. Indeed, the public protector accepts the president's good faith in this regard in a section 7I notice and in parts of her report. In a Section 7I notice, she concluded that his conduct referred to above, although in good faith, is inconsistent with his office as a member of cabinet and therefore in violation of 96(1) of the Constitution. And then 63 says this is repeated by the public protector in the executive summary of a report. And then if we go down, they discuss what good faith is and the evidence. And then 64 says, what is more troubling is that the president dealt with the public protector's acceptance of his bona fides when he responded to his Section 798 notice. His response recorded that the public protector has correctly found that the president acted in good faith. That should be the end of the matter. Any suggestion that the president contravened the executive ethics code is incompatible with the public protector's own finding that his response to Mr. Mkhwebane was given honestly and in good faith. In a response in a final report, the public protector referred to the submission as preposterous. This response delays a deep-seated inability or refusal to process facts before her in a logical and fair-handed manner. Such a response is difficult to reconcile with the constitutional obligations. Furthermore, it was totally irrational for the public protector to make a finding that the president misled Parliament on the basis that he should not have answered Mr. Mkhwebane's question before first checking the facts. The president had sufficiently clarified how it came about that he answered Mr. Mkhwebane's question on the spot. So this was to finish off the point I made on good faith yesterday. And then and to show that the court dealt with what was before it, and Advocate Mkhwebane is going to go through the facts as it appears in the affidavit. So one has to, and having shown you what was said in the affidavit on the 16th of November versus what was said in the affidavit on the 14th of November, I then want to take you to the judgment of Potterell J in relation to the interim relief pending the finalization of the review, where the point is taken that the reference to the code, the 2000 code, is wrong. And if one looks at that judgment, which one sees at number 36 of bundle C3. We go first to paragraph 22 of the judgment. Sorry, I have a different, right. To give a, this is the finding that Gordhan had violated the Executive Ethics Code in deliberately misleading the National Assembly. The judge quotes paragraph 23A of the Executive Ethics Code as members of the executive may not willfully mislead the legislature to which they are accountable. So what the court does is, even though the provision in the report refers to the 2007 code, the judge uses the correct code in the judgment. And this sparks off when the public protector files her answering affidavit in the matter in opposing in seeking leave to appeal from the judgments, from the Potterell judgment, which you find is it's the affidavit in volume 35. And if you go to paragraph 87, now we've got it. Right. So this is the affidavit that Advocate Mkhwebane deposes to on the 16th of November, and she says in the report 3.5, I set out the special circumstances justifying her decision to assume jurisdiction. There is no basis on which the court quo failed to deal with these factors. As it is submitted in proceedings before the Constitutional Court quo, and Mr. Gordhan committed 8 gross errors in regard to the issue of whether I have jurisdiction, in that she is barred to entertain the complaint under section 6.9. Maybe we should just go one paragraph up so that the members can see the context. Okay, this relates to the argument of Mr. Gordhan that the public protector is dealing with. So let's go down. First, the court disregarded the public protector's report, which stated on paragraph 2.1 that the first complaint was lodged with my office on 12th October 2018 by an anonymous whistleblower. The second complaint was lodged on 8th November 2018 with my office by Mr. Floyd Shavambo. This is the judgment that she says she's referring to the Patrol J judgment. Tellingly, the court does not discuss the jurisdiction issue when it considers my finding that Gordhan violated the Constitution and the Executive Ethics Code during his reply to a parliamentary question in November 2016. I found that the allegation that Gordhan violated the Executive Ethics Code of Ethics by deliberately misleading Parliament through failing to disclose that he met a member of the Gupta family was substantiated. I stated in my report that Mr. Gordhan conceded to not having disclosed that he actually met a member of the Gupta family and an associate of the family in 2010. Contrary to the judge's strained interpretation and misreading of the report, the failure to disclose happened in 2016 when Gordhan responded to a parliamentary question, and not in 2010 when he met the family of the member of the Gupta family. And so she says she's got jurisdiction. So I'm drawing the members' attention to the judge's strained interpretation of the Executive Ethics Code in that matter. And then if you go to paragraph 90, I could further committed a gross misinterpretation of the applicable the Executive Ethics Code. Section 2.3 expressly states that members may not A, deliberately or inadvertently mislead the President or the Premier, or as the case may be, the legislature. Inexplicably, the High Court chose to rewrite the said provisions of the code and adopt Mr. Gordhan's view that the code only prohibits willfully misleading the legislature to which they are accountable. The High Court did so by deliberately omitting the words inadvertently mislead from the actual code. The High Court states on paragraph 22 of the judgment, the review ground set up by Mr. Gordhan is not that he did not willfully mislead the National Assembly. I found that Mr. Gordhan dishonestly concealed the fact that at the Ambani meeting there was a Gupta present. As if to highlight its grossly misplaced interpretation of the code, the court went on to state on paragraphs 23 and 24 the following. The EFF submitted that it matters not that Gordhan may not willfully have misled the legislature. An innocent mistake is sufficient. This is, of course, contrary to the wording of paragraph 2.3a of the code, specifying that it must be done willfully. Right? And then there's then a reference to the South African Code of Ethics being in line with best practices from Westminster style parliamentary system similar to our own, and a reference to the UK position. And midway through the paragraph, it says, likewise, the South African Executive Members Ethic Code states at para 2.3 that members may not deliberately or inadvertently mislead the President or the Premier, as the case may be, the legislature. And then there's a reference to the Scottish Code. Go down to the following paragraph. There is no evidence that Mr. Gordhan ever attempted to correct his alleged inadvertent errors at any time after making the misrepresentation he did. The court was plainly wrong, as the code makes clear that even inadvertent misleading of the legislature is sufficient. This allegation is made in the supplementary affidavit, and I deal with it therein. right? Um, um, so effectively, the position adopted in the Gordhan case is different to the position adopted in the Potterell judgment. So if we if you and attached to this affidavit, if you go to paragraph 231, just go one up again. Okay, so that's a repeat of the Westminster style. Go down. Top. 231, constitutional purpose for targeting both advertent and inadvertent leading is so as to discourage members of the executive from relying on a lack of knowledge or pleading ignorance on matters falling within their competences. In other words, the code seeks to ensure that the member of the executive cannot rely on ignorance of the law to avoid the consequences for a lapse of their ethical duties. For completeness, attach a copy of the Executive Ethics Code that was applicable and was relied on by the public protector as PP6. And I want to take the members to PP6 in a moment. I point out that this was the code that was the subject of litigation in the EFF judgment of the Constitutional Court. If the Executive Ethics Code relied on by the public protector was the incorrect code, then the Constitutional Court in the EFF judgment made findings based on the wrong code. So if you go and you go down to EFF 6, which should have to go into volume 7. It's not on this one, it's on the next volume. So go to bundle E, and you would have to go to the volume 7. Yeah, and you click on page 163. So yesterday I had made a submission to the committee that nowhere did I find in the CR 17 documents in the court a reference to the issue of the Nkandla judgment, etc. One does see a reference to that in the Gordhan papers. So if you go up and you look at PP6, go to 163. You're in the wrong volume, you're in 4. You need to be in 7. Now, you need to go out of 4 entirely because we want to go to index volume 39, PP6. You've got to go to item 7. Uh, 163. Now, the is while you're in line item 7, volumes 38 to 48, and you've got to click on the PDF 163. Right? PP6, which is attached to the affidavit, is in fact the 2000 code. So what we see is, although in the Gordhan related matter, the affidavits rely on the ostensible 2007 code, what is annexed to the papers is the gazetted 2000 code. And so on that note, Chair, did you?
You want to move to another document? Okay. Can I just, honorable members, if I can just be given 5 minutes to attend to something just here, we'll just take a 5-minute break. Thank you.
Recording stopped.
thank you very much for your patience and allowing me to attend to that issue. At some point, you will be briefed. Thank you. Let's proceed, Advocate Bauer.
Yeah, I'm in the Gordhan matter and I want to go to so what happens is we have this judgment in the full bench in the Gordhan matter handed down. There's then an application for leave to appeal against the judgment to the Supreme Court of Appeal. When we deal with the Gordhan matter in greater detail, I will take you to the Public Protector's affidavit that was filed at the Supreme Court of Appeal in the context of the evidence that we had last week, Thursday and Friday. But for the moment, I want to deal with the EMEA matter. I want to take you to the judgment in the leave to appeal, which is handed down by the full bench, which is at page 139 of Bundle E, 8.3, page 139. And if you go down to page 139, yeah, right. And the full bench records that this is an application for leave to appeal to the Supreme Court of Appeal against the judgment and order of this court handed down on 7 December 2020 upon the grounds set out of the notice for leave to appeal. So for the layperson for me to explain is, if you take issue that the court has erred in respect of its findings and its orders that it makes, you have to apply to that court under the procedure set out and file a notice for leave to appeal in which you indicate where, with due respect to the judges, where you regard the court to have erred. That court then hears your application for leave to appeal. In some instances, the judge will ask for heads of argument, and then they will either grant you leave to appeal to the SCA or to the Constitutional Court, depending on how you ask. So this is the judgment that this court hands down in the context of the application for leave to appeal. And if you look at go down in the paragraphs, the judges say full reasons were provided in the judgment sought to appeal against, and they're not going to provide furnished reasons, and they won't deal with each and every ground of appeal raised. They point out certain things. And then go further down and they go to paragraph 11 of the judgment. And the court then says the manner in which the first respondent is capable of reaching conclusions which are unsupported by the facts and the law, a fact which supports the improper motive and biasness ground of review, is demonstrated when she deals with the applicable executive ethics code in relation to the Ambani meeting. It is an irrefutable fact that the Executive Members Code 2000 does not punish inadvertent mistakes. Yet the first respondent states in a heads of argument that the finding that the applicable code does not punish advertent mistakes is incorrect. To state with that was not the finding of this court is explained above. Yet the first respondent perpetuates the misunderstanding by stating the applicant is cognizant of the fact that unlike the 2000 version, the 2007 version of the Executive Code thus reads, members of the executive may not willfully or inadvertently mislead the legislature to which they are accountable. Paragraph 12, the court say, the fact is that there is no 2007 version of the Executive Ethics Code, and this was conceded by counsel who represented the first respondent during the hearing of this matter, Mr. Masuku. According to Mr. Masuku, the first respondent had based the findings in this regard on a ministerial handbook. The repetition of the misunderstanding in an application for leave to appeal can only be described as astounding. It bears mentioning that the misunderstanding was the basis on which the first respondent recommended remedial action with potentially far-reaching consequences against Minister Gordhan to the President. You will know when I started out the address, we for another reason may come back to this judgment at a later stage. I started off with the rescission application that occurs as the last set of affidavits that gets filed in the Constitutional Court. And I want to go to the President's response to the application, which you'll see at bundle E 10, and it's the President's answer at number 2. You're in the wrong document. Right. Now, what the President does in this affidavit, or the President's legal representative deposes to this affidavit, and he essentially deals with a number of the arguments that I have taken the committee through with reference to the affidavits. Just go to the bookmarks. And attached to this affidavit at PH4 is the extract from the Public Protector's heads of argument that is before the court in the application for leave to appeal that I've just read you the extract from the judgment from. So go down. Right. And it basically says what the leave to appeal is about. Go further down. It doesn't have the full one. It goes to the 4th era, which is relied upon, which is the applicable executive code. The finding that the applicable code does not punish advertent mistakes is incorrect. The applicant's cognizance of that fact, unlike the 2000 version, the 2007 of the version of the code reads thus: members of the executive may not willfully or inadvertently mislead the legislature in which they are accountable. This is not what the 2007 version of the executive code says on the version that is put forward. It was deliberately or inadvertently. In any event, the applicants have already withdrawn the remarks insofar as Potter's interpretation of the code is concerned. It is unfortunate, and this goes in respect of the attack on Judge Potterl. Go further down. Right. Just go to the end of the heads of argument. And we see that this heads of argument was prepared by Advocate Mkhwebane on the 19th of March, 2021. So the person who argued it in the judgment was Advocate Masuku, but that was Advocate Mkhwebane who drafted the heads. Right. So go to the substance of the affidavit. I just want to briefly take you through down. Right. So we see the deponent is the attorney of the president. You can just scroll down and I'll talk through it as we go. And it essentially deals with the arguments in this affidavit in respect of the allegations on the reliance on the Nkandla judgment and a number of the submissions that I've put to you, which I've taken you through to the source documents instead of just solely relying on the affidavit which was filed in the Constitutional Court in the rescission application. Go down to the heading that says there's only one true code, right? And go further down, it then refers to the section 2.1 code and the promulgation of the code being stopped at paragraph 5. It says it's common cause that the president promulgated this code. And then it deals with submissions that the public protector makes in this application. Go further down. Go further down. We've dealt with those paragraphs of the public protector's affidavit yesterday, or the ministerial hang code. We've dealt with the entire argument relating to the Nkandla judgment, so you can skip the section. Right. And then it deals with what the public protector says in paragraph 32, which we've dealt with yesterday. Go further down. Right. And then it makes the point that the public protector had a copy of the 2000 code. It was annexed to the founding papers, and it makes a reference to the references in the report. Go down where the public protector refers to the code correctly. Go down. Past the subparagraphs of 15. I took you to the actual paragraphs. It makes the point that in the application for review, the admission to the correct version of the code being in 5.1.19. I took you to that. Go further down. We've dealt with those paragraphs where she admits that the correct version of the code appears at paragraph 5.1.9. We've been through that affidavit. Right. Go further down. And then he deals with what the full bench of the High Court had to say in paragraph 21. With those references, we took you through to the paragraphs of the High Court judgment. Go down. He then deals with the application for leave to appeal and the conclusions reached by the court in that. Go down. He deals with the issue that I just took you to in the heads of argument. Go further down to this court, addressed it. And he sets out the history of the matter in that regard. Go down. And then there's a point made that the public protector was guilty of dishonesty, having on the same issue on the application for review brought by Minister Gordhan. And I base this follow description of a conduct in that case on the documents in the case which are on public record. And then it takes him through the report, go down, and the findings that Minister Gordhan had been deliberately misled. Paragraph 5.1.11 of a report relating to which I had just taken you through on paragraph 2.3. And then the application for interim relief before Justice Potterell, her using of the correct code in paragraph 2000, in paragraph 22 of a judgment. Go down, go past that. And he refers to the relevant pages of the affidavit on where there was an attack on Justice Potterell for actually relying on the 2000 code, and I read you paragraph 95. Go down. He refers to a paragraph I didn't take you to, which was in paragraph 228. That says, go down. It says Mr. Gordhan and Potterell J committed a gross misinterpretation of the applicable, the Executive Ethics Code. Section 2.3 of the applicable Executive Ethics Code expressly states that members may not deliberately or inadvertently mislead the President or the Premier, or as the case may be, the legislature. Inexplicably, the High Court accepted Mr. Gordhan's misapplication of the code and chose to rewrite the said provisions of the code, contending that the code only prohibits willfully misleading the legislature to which they are accountable. Go down. And then it points out that 3 paragraphs later, the public refers to the annex code, and then annexes PP6, which I showed you, was actually the 2000 code. Go down. And here the point is made by Mr. Harris at paragraph 30.4 that she for the first time invoked this court's judgment in the Nkandla case in support of her contention, but turned it on its head by swearing on oath that in reliance of the Nkandla judgment, she applied the code of 2000. And the point is made that the attack on Patrol J and Minister Gordhan was all the more scandalous because the public protector made it in an affidavit dated 16th November 2019. That was 2 days after she deposed to an answer in the present case against the president, in which she had admitted on oath that the correct rendition of paragraph 2.3a was as appears from the Code 2000, and points to a contradiction on oath in two affidavits made on 14th and 16th November 2019. And then further in paragraph 32, the full bench then refers the extract of the judgment in which it has a scathing criticism of the public protector's inconsistent interpretation of the ethics code and an attack on Patrol J in doing that. And it says, but what compounds the public protector's misdirection is that she then makes a complete about turn by departing from her report and now argues that an inadvertent or mistaken misrepresentation violates the executive ethics code. In doing so, she then shifts her focus to the judgment of Patrol J, who presided over Part A in this application, which is paragraph 58. But instead of merely recording a disagreement with the court's interpretation, she launched into a scathing, unwarranted, and personal attack on the integrity of the learned judge. She even goes as far as to accuse the learned judge of a gross misinterpretation of the code and of deliberately omitting words from the code. Further down, apart from the fact that the personal attack on the learned judge is shockingly inappropriate and unwarranted, the public protector's reading and interpretation of paragraph 2.3a of the Executive Ethics Code is wrong in law. The code prohibits members of the executive from willfully misleading the legislature. The wording of the code is clear and does not contain a provision that an innocent mistake constitutes a contravention of the Executive Ethics Code. To claim that Patrol J deliberately omitted the words inadvertently mislead from the actual code is simply astonishing. Besides being a public protector, Advocate Mkhwebane, officer of this court, owes it a duty to treat the court with the necessary decorum. She not only committed an error of law regarding the code, but was also contemptuous of the court and Judge Patrol personally. What makes this reprehensible conduct worse is that the remarks of Advocate Mkhwebane were made under oath when she ought to have known about the falsity thereof. This clearly held the possibility of misleading this court. This is conduct unbecoming of an advocate and officer of this court. She owes Judge Patrol an apology. The registrar of this division is requested to send a copy of this judgment to the Legal Practice Council for consideration. And then we know, as I showed you, that leave to appeal, stop quick, to the SCA was applied for, and there's the extracts of the heads of argument, to which I've already taken you. Go down. And then it takes you to the portions of the judgment to which we already dealt with. Go further down. Right. And following the dismissal of the application's leave to appeal, the public protector applied to the SCA for leave to appeal. At that stage, the application was still pending. This history of the Gordhan case again illustrates the public protector's dishonesty in the suggestion that in reliance on this court's Nkandla judgment, she consistently and conscientiously relied on the version of the code published in the Ministerial Handbook in 2007. So on that note, I want to take you to what was put before this committee, and that we find in the public protector statement at 629. Page 629 at paragraph 291. And I know the committee would have read it already, and I don't want to belabor the point, but I think it's important, having taken you through the court records, that we just ended off by showing where this fits into the statement very briefly, and point you that it occurs from paragraph 219 onwards at page 625. And the very first paragraph right? The first paragraph of the statement says, I must state, and this affidavit was deposed to 14th March 2023. 91. Page 629. And the public protector then said and gave evidence that the issue on the written argument, she says, I must state that on the issue of the code, there is a 2000 code and a 2007 code. Paragraph 292, the 2007 code has since repealed the 2000 code. That's one of the issues that we would have to canvass in evidence with her. But the president based his argument on the repealed 2000 code for obvious reasons. And those obvious reasons being that it relates to a willfully misleading as opposed to deliberate and inadvertent. Then at 293 it says, though my findings were not based on the 2000 code, since this 2000 code was repealed by the 2007 code, which has consistently been applied by my predecessor and endorsed by the Constitutional Court in various matters. The 2007 code was clear that the member of executive cannot willfully and inadvertently mislead the legislature. That is a different version of the 2007 code. The court was therefore wrong to make its findings based on the repealed code. And then she says, as this is a sensitive matter, she will deal with it in oral argument, which she did, and we would then have to question her on that issue. And it will say that evidence will be laid to demonstrate beyond any question that my references to the 2007 code were based on a historical reliance for the Office of the Public Protector on that code long before my assumption of office. And in this regard, specific reference will be made to previous reports, including, among others, the Nkandla report, as well as prominent reports such as Shikeka, Tina Pule, Tina Jumut-Peterson, and the John Block reports. Again, we would have to show Public Protector didn't take you to these specific reports, but we would then in evidence have to show you, we would have to ask her about those reports specifically in questioning her. In paragraph 295, for now it suffices to say my findings of the breach of the 2007 code was well-founded and substantiated. And the president is then told that, or we're then told that the president takes a technical approach in this matter, leaves much to be desired, especially when he stands for ethical leadership, but goes on to avoid accountability by ensuring that the CR17 campaign existed independently, although he does not argue that it's registered as a separate entity. So that was his campaign to be faced to do that. So those are the issues that relate in the court papers to the application of the EMEA code. And we ended up with the evidence last week saying that the correct code is the 2000 code in oral argument, in the oral evidence. Chair, I'm going to. Chair, Advocate Mayosi is going to take the next section. Could we ask for a 10-minute 10-minute adjournment just for her to take over?
Okay, in that case, it means we'll take an early tea and use that 10 minutes to have a tea break. And then we'll come back, we'll continue. Thank you. We pause for 10 minutes, colleagues. Thank you. Let's proceed, Advocate Mayosi.
Thank you, Chair. Good morning to members on the virtual platform, to PP and members of the public that are present. Chair, we're still dealing with the CR17 Busasa issue, and the portion that I'm going to be dealing with now is the portion dealing with the complaints and the responses to the complaints. As the committee will now be aware, both complaints that were lodged by Mr. Maimani and Mr. Shivambu, they were lodged pursuant to EMEA, which is the Executive Ethics Act, about which much has been said so far. In essence, Mr. Maimani's complaint, Sepo, I don't know if you already know now, bundle H in the PP's documents, item 31.7.5. If you go to the Busasa report, the PP's report in Busasa, right? It's MCR1. Yes, it's an annexure, but it's page 72. You got it? Yes. So Mr. Maimani's complaint appears in the PP's report, in essence, from page 7 onwards. But for present purposes, Sepo, if you could go to page 75. Thanks. Let me just go there. So go down to Roman 5. Thanks. So he, according to the executive summary in the PP's report, Mr. Maimani's complaint consisted of the following: that on the 18th of October 2017, an amount of 500,000 was paid into the account of EFG2. The money was paid from a personal account of Mr. Gavin Watson, who was the CEO of AGO African Global Operations, formerly known as Busasa, into the account of Mioto Trading, a company that was closely associated with Busasa. From there, it was paid to the account of EFG2, which was said to be a trust foundation account of the son of President Ramaphosa, Mr. Andile Ramaphosa. Go down, Sepo. Complaint continued that on the 6th of November 2018, during a question session in Parliament, the President violated the Executive Ethics Code by deliberately misleading the National Assembly in his reply to Mr. Maimani's question. And the nature of the question that was posed to Mr. Maimani is described in paragraph C. The President's response is in paragraph D of the executive summary of the PP's report. In essence, the President confirmed that he was aware that AGO had paid his son, but had been satisfied that it was a lawful payment for services rendered by a consultancy firm owned and operated by Andile Ramaphosa. Mr. Maimani also had a sworn statement, which we now know was from the erstwhile tax consultant, Mr. Pete Venter. It is recorded on page 150. We're still on the PP's report, Sepo. Go to paragraph 5.3.10.42, page 150. Yes. According to him, the affidavit referred to by Mr. Maimani in his complaint was prepared on his behalf. and that certain parts of what is reflected in that affidavit is not all true, as certain things have been changed. However, go down, Tsepo. Everything pertaining to the transfer of 500,000 is true. Mr. Venter stated that in fact, he had signed the affidavit referred to under duress. This is a summary of what the PP provides in her report of the contents of Mr. Venter's affidavit. There are no details given in the PP's report or in the affidavits that were filed in the litigation as to precisely how it is that Mr. Venter is said to have signed an affidavit under duress, whilst on the one hand confirming the truth of the contents of that affidavit, and yet on the other hand indicating that parts of it were not true. This is one of the issues that will have to be taken up with the PP when she does come to give evidence. That is the nature of the duress that was said to be applied to Mr. Venter in the conclusion of the affidavit. Another issue in relation to the approach, to the investigative approach that was set out in the Mail and Guardian case. The PP may be requested to indicate what steps by way of an independent investigation were taken by her in order to verify the veracity of this affidavit, given the disclaimers that Mr. Venter gave in the content of the affidavit itself. We do know, given from what is in the public domain, that this affidavit of Mr. Piet Venter's served before the Zondo Commission of Inquiry, the State Capture Inquiry, and that Mr. Venter also gave evidence there. This affidavit may therefore be considered by this committee under the directives that apply to the work of this committee in relation to its ability to consider affidavits that served before other inquiries. So when it comes to closing arguments and deliberations, the committee will have to form a view as to what view it takes of this affidavit that served before the State Capture Inquiry. There is a dispute of fact, though, between Mr. Venter and the late Mr. Gavin Watson, in that Mr. Venter indicated that his instructions, the instructions that were given to him, was that the money was for Andile Ramaphosa. That's the one version. And Mr. Watson, on the other hand, stated that he had not given this instruction to Mr. Venter. Both of these versions, which indicate the dispute of fact, occur in statements that were made under oath. It's not apparent from the PP's report, and this is another issue that will have to be taken up with her. It is not apparent how or if this dispute of fact between the two versions was resolved in the report. It doesn't appear from the summary of the evidence of Mr. Watson that is contained on page 80 of the PP's report. The dispute of fact doesn't appear from that summary, but it does appear from his affidavit, which is reproduced on page 32 of the PP's report. That's on page 151, Tsepo. Yep. Up, Tsepo. No. Page 80, yeah, go down. Page 80 of the actual report. Yeah. Wait, no. Yes, so Mr. Venter's version appears there at paragraph 5.3.10.43. Mr. Venter indicated that Mr. Watson and AGO took advantage of his small company to effect some of their financial transactions. and that he was unable to refuse, hence the instruction to him to transfer the 500,000 instead of using their own accounts. Mr. Watson's version appears on page 32, Sepa, paginated page 32. Go up. Yeah. Go to paragraph 8. Typed page 32, is that correct? Okay. Typed page 32 of the report. No. Page 32 of the actual report, the PP's report. You see the page numbers on the bottom right-hand corner. What I'm trying to take the committee to is what Mr. Watson said in his own affidavit, which is reproduced in the PP's report, about whether or not he gave an instruction to Mr. Fenter in relation to donating the money. Yeah. Go down, Sepa. Yes. Go down a bit. Yes, stop. If the committee will see where it says add paragraph, it's not very legible, but it's paragraph 8, add paragraph 8.4 of something. It is said that I did not instruct Fenter that the donation was to the Andile Ramaphosa Foundation. So this in essence is to demonstrate what I alluded to earlier as to the dispute of fact in relation to the version put by Mr. Fenter and the version put by Mr. Watson, and the issue being that when it comes time to interact with the PP, it may serve well for the committee to request her to just clarify how she resolved that dispute of fact for the purposes of reaching her conclusions and for the purposes of her report. So it is so that the statement which Mr. Mkhwebane made indicated that the 500,000 was paid to EFG2 and it was for Mr. Andile Ramaphosa. Subsequently, he also says that on the 16th of November 2018, the president sent a letter to the speaker of the NA. This is after the question and answer session, sent a letter to the speaker of the NA indicating that the payment was actually a donation to his campaign to be elected as ANC president in December 2017. Mr. Mkhwebane then says, it is my concern that the set of facts related above reveal that there is a possibly an improper relationship existing between the president and his family on the one hand, and the company AGO, formerly known as Busasa, on the other hand. On the other side, the nature of the payment passing through several intermediaries does not accord with a straightforward donation and raises the suspicion of money laundering. The committee will have been referred yesterday to the definition of money laundering as was set out by the Constitutional Court in its judgment. You don't have to go there, Tsepo. Advocate Bauer took the committee there yesterday from paragraphs 140 to 143 of that judgment. Again, this is one of the issues that will be taken up and will arise during legal argument. The question of whether it is sufficient for money to be passing through from one account to the other to constitute money laundering, and whether or not there needs to be an underlying criminality in the initial transaction in order to give rise to a suspicion of money laundering. But that too is an issue for argument later on. Mr. Mkhwebane then said that the alleged donor is further widely reported to have received billions of rands in state tenders, often in irregular fashion. Here too, an issue arises to be taken up with the PP when she does appear before the committee. The issue being what steps she took, again, following the investigative approach set down in the Mail and Guardian case, what steps she took to investigate any links that may have ensued to state tenders as a result of the 500,000 Rand donation. Mr. Mkhwebane also stated that he was concerned that the president may have lied to the National Assembly in his reply to the question on the 6th of November 2018. He referred to several intermediaries, which I think Advocate Bauer will deal with in the fuller context of the CR17 campaign with reference to money laundering. And Mr. Mkhwebane's concerns around the donors having received billions of rands again in state tenders. And as mentioned earlier, this is an issue that will be taken up with the PP when she does come to give evidence before the inquiry. With reference to the complaint of Mr. Shivambu, the PP, as members will recall, was obliged to investigate this complaint. As members will be aware, the PP has the jurisdiction to investigate a violation of the Executive Ethics Code by a cabinet minister on receipt of a complaint by a member of the National Assembly under a mayor. The complaint was that the president had misled the House There were two issues that Mr. Shivambu raised in his complaint. First, it was whether the statement made by President Ramaphosa in the National Assembly on the 6th of November 2018, that he saw a contract between his son's company and AGO is true, whether such in fact existed, one. Two, whether the president saw the contracts alluded to. So the issue raised was quite simply whether President Ramaphosa deliberately misled Parliament in violation of the Ethics Code. In his response to the complaints, the president asserted that the complaint was unsubstantiated and no finding to that effect could be justifiably made in the report. In his affidavit, the affidavit of the president in response to the complaint, Sepo, please go to the president's founding affidavit, paragraph 106, page 44. Paragraph 106. In his response, the president said the following in his founding affidavit: I have noted that the public protector does not make a finding in relation to Mr. Shivambu's first complaint, namely whether it is true that a contract exists between AGO and Andile Ramaphosa, and whether the statement made by the president that he saw the contract is true. It is clear that there is no basis for the complaint of Mr. Shivambu. However, the public protector's complaint is similar. However, the public protector does not deal with it. Instead, she merely states that Mr. Shivambu's complaint is similar to that of Mr. Mkhwebane, and that after receiving Mr. Shivambu's complaint and another anonymous complaint, she decided to consolidate the two complaints into one investigation for administrative purposes. The public protector then deals with this paragraph, responds to this paragraph in her own affidavit at paragraph 195.5. Sepo, that's at page 852. Paragraph 195. So the entire response in paragraph 195 is relevant, but from paragraph 195.1 up until paragraph 195.7. But I'd like to read for the committee paragraphs 195.5, where the PP says the following. I further deny that I did not deal with the complaint of whether a contract existed. It was not in dispute that the president's son, Mr. Andile Ramaphosa, had business contracts with African Global Operations for which he was paid large sums of money for services he rendered to the company. Once again, the president fails to address the facts of the matter and instead looks for all sorts of technical issues to fault my investigation. This is simply disappointing and an impermissible attempt at avoiding taking responsibility by a head of state. Save as aforesaid, the allegations contained herein are denied. Now going to what the High Court found in relation to this matter. So we'll go to the High Court judgment. Paragraph 73. The High Court stated as follows. Finally, it is necessary to deal with an important anomaly in the report. Although the public protector decided to consolidate the two complaints, she made no findings in respect of the complaint of Mr. Shivambu. The public protector included the agreement and anti-corruption policy between AGO and Andile in her report. Accordingly, they clearly existed. However, she did not draw the obvious conclusion from this evidence, namely that the president had not misled Parliament in this respect. She does not explain her omission. In all fairness, the president was entitled to be exonerated on this complaint. Instead, the public protector ignores the point of Mr. Shivambu's complaint, which was to question whether the president misled the National Assembly about his son's contract. Going to what the Constitutional Court found in relation to this item, we'll go to the Constitutional Court judgment in paragraph 94. Was it? Yeah. We found it. Excuse me, Chair. Paragraph 94. Mm-hmm. So this is what the Constitutional Court said in paragraphs 94 and 95. As appears from footnote 16, the complaint by the leader of the official opposition required the public protector to investigate 3 issues. These were an improper relationship between the president and his family on the one side and African Global Operations on the other side, the suspicion of money laundering and whether the president lied to the National Assembly, as appears from paragraph 36. You cut me, Sepo. As appears from paragraph 36, the complaint by the Deputy President of the EFF asked the public protector to investigate 2 issues. These were whether the statement made by the president in the National Assembly to the effect that he saw a contract between African Global Operations and his son was true, and whether the president had deliberately misled Parliament in violation of the code. None of these complainants had asked the public protector to investigate the president's failure to disclose benefits he derived from the CR17 campaign. The only reference made to donations in the complaint by the leader of the official opposition was in relation to the issue of money laundering. Evidently, the complaint was not that the president is suspected of having laundered money. The complaint was that the donation made by African Global Operations passed through several intermediaries, and that gave rise to the suspicion of money laundering. But the evidence by the donor and the person who made the payment quashed the suspicion. However, as the PP indicated in her affidavit in the application for leave to appeal, that's on page 1464. Item 37.1.5, page 1464, paragraph 27. I found that in respect of the issue of whether the president exposed himself to any situation involving the risk of a conflict between his official duties and his private interests, or used his position to enrich himself and his son through businesses owned by African Global Operations, this was substantiated because the PP then cited the provisions of section 96 of the Constitution, go down, Tsepo, the content of which is cited there. The Executive Ethics Code is the code envisaged in section 96 of the Constitution. The Executive Ethics Code is the code with which members of cabinet, deputy ministers, and members of the provincial executive councils must comply in performing their official responsibilities. The PP went on further to state what she did in paragraphs 27.3, citing paragraph 2.3 of the Executive Ethics Code, paragraph 2.7, 27.4 as well, citing paragraph 3.1 of the Executive Ethics Code, paragraph 27.5, go on. Down. And the remainder of the contents of paragraph 27 and its sub-paragraphs. A question which will arise for the PP when she does come to testify before the committee, and this was alluded to in Advocate Bauer's address yesterday, in which members will recall that what was indicated was that this was a complaint in terms of EMEA, and under section 3 of EMEA, the PP only has jurisdiction to deal with breaches of the executive code. The suggestion in her affidavit in the application for leave to appeal, however, suggests that she approached the matter not as a breach of the code, but a breach of section 96 of the Constitution and a breach of the EMEA Act itself. This is an issue which the committee should take up with the PP when she does come to testify, and this is an issue which in any event will be pursued during legal argument as to what the proper approach was in those circumstances, given the requirements of the code and the EMEA Act. The president, in his correction to Parliament, Tsepo, you will find that on page 178. It's MCR 3. One 187. Sorry. Then In his correction to Parliament, the President indicated as follows. The President's reply to the question was based on the information that was at my disposal at the time, the President said, regarding a business relationship that my son's company has with the company African Global Operations. Confirmed consultancy and stated the consultancy services were provided by my son's company to African Global Operations in a number of African countries other than South Africa. He informed me that South Africa was specifically excluded to avoid a potential conflict of interest. He was subsequently informed that the payment referred to in the supplementary question by the leader of the opposition does not relate to that contract. The President stated, I have been told that the payment to which the leader of the opposition referred was made on behalf of Mr. Gavin Watson into a trust account that was used to raise funds for a campaign established to support my candidature for presidency of the National African Congress. The donation was made without the President's knowledge. He was not aware of the existence of the donation at the time, and he stated that he answered the question in the national, he was not aware of the donation at the time that he answered the question in the National Assembly. So an issue, again, that it may be pertinent to take up with the PP when she does come and testify before the committee is that it is not apparent from the PP's report what evidence the PP relied upon to, let me rephrase that. There's no evidence in the report, and this issue is an issue that will have to be taken up with the PP to indicate that the President did not find out for the first time about the 500,000, specifically after his question session in Parliament on the 6th of November, 2018, as the President stated in his response, when Ms. Nicol told him of that. It's not apparent from the report, and for that reason, this is an issue that the PP should be asked to indicate the evidence that she relied on. Andile Ramaphosa was not subpoenaed to appear before the PP, but he was asked to provide an affidavit. His affidavit that he provided to the PP is dated 21 February 2019, and it is recorded in the PP's report on page 69, Sepo, paragraph 5.3.10.28, page 69. That's the report, page 69, not the record. Yeah, the report, page 69, which states, yeah, that's about paragraph 5.3.10.28. So the PP says at paragraph 5.3.10.28, although I did not conduct interviews with Mr. Andile Ramaphosa, he made submissions to my office in a form of an affidavit dated 21 February 2019, in which he explained his business relationship with AGO. This was confirmed by the advisory mandate and the anti-bribery and corruption policy signed between his company, Blue Crane, and AGO. If you go to paragraph 5.3.10.32, Sepo, further down. That's the contract. the advisory mandate, but I want to see what the PP further says. 5.3.10.32. The PP continues, he also submitted invoices generated and in respect of services rendered by his company to AGO for the period 5 December 2017 to 28 February 2018, as well as bank statements, which confirm payments received by his company from AGO over this period. According to the bank statements provided to my office by Mr. Andile Ramaphosa, he received about 4 monthly payments of 171,000, which in total was about 684,000 from AGO for the period mentioned above. So as stated previously, the PP did not interview Mr. Ramaphosa, but rather sought his input by way of an affidavit from him. One of the issues to be raised with her is, given the findings, the following findings that she made, given that the finding that the president's family had an improper relationship with AGO, and given the findings regarding Andile Ramaphosa's business relationship with AGO and the conclusions that she reached that funds were paid to him before the contract was signed, an issue that should probably be taken up with the PP with her when she does come to give evidence is whether, again, following the Mail and Guardian investigative approach of following the evidence, whether Mr. Andile Ramaphosa should have been interviewed. It's not clear from the report itself and also from her oral evidence to date why an interview with Mr. Andile Ramaphosa was not conducted, and why only an affidavit was sought from him for the purposes of his input to the investigation, one, and given the conclusions that were then reached by the PP in her report. The PP states the following at page 844. This is her answering affidavit. Tsepo. Item 31.7.5, 44, yeah. Paragraph 184.1.4, yeah. The PP says in her answering affidavit, what is clear is that the president was aware of payments to his son at least 2 months prior to Mr. Mkhwebane raising the issue, and that on inquiring from his son informed him that in December 2017, his company Blue Crane Capital had signed an advisory mandate with African Global Operations. And then with reference to the president stating that he was not aware of the Gavin Watson donation, the PP said the following, go to 184.1.6, Tsepo. This is despite the fact that both Mr. Chauke and Mr. Andile Ramaphosa had actually discussed the issue with the president as early as September 2017. It's simply contradictory, she says, to say the least. In the PP's interview with the president, the PP asked the president why he did not ask the speaker for time to answer the question, because it wasn't related to the VBS issue, which formed the subject matter of the questions, of the question and answer session that was currently taking place, that was then taking place in Parliament. The president responded to this question by saying the following, a quick Tsepo, page 199. Yeah. Page 199, Tsepo. Yes. Yes. That's where we are, PCR. So in response to this, members will recall what I said earlier is that during the interview with the PP asked the president why he didn't ask the speaker for more time to answer the question, in particular, because the question and answer session related to a different issue. The president responded by saying the following: it happened in a heat of the moment. And I think what really stung me was here is the president. Here is his son, and there seems to be a corrupt relationship. And that is what prompted me to answer on my feet, because I thought, let me give an explanation, lest after the hearing, it goes around being said that the president has brought his son, is benefiting from a corrupt relationship and all that. So the connotations of that is what prompted me to respond. And also because I knew from what he had shown me that there was actually a contract, that whatever relationship he had with the company was based on a clear and straightforward business relationship. So that is, I think, what prompted me to answer. Because for me, it was like, as I said in my statement, that it was an attack. That because you are the president, now your son is in a corrupt relationship, you are all benefiting from this relationship, which in my view is not correct. And I felt the need to answer there and then and there. The PP agrees, and she says, so this EFG2 is this trust foundation. So Andile has no relations to that. The president says none whatsoever, and so on. Further at 209, Tsepo. Go down. Go down. Go down. Go down, Tsepo. Up, back up. So the president continued there. Now, he says, I'm reading from where it says now. Now, it is important to know that this was a follow-up question on a matter that was unrelated to the original one. The PP says, I therefore didn't have an opportunity to reflect on the question in its totality, to examine what was being averred in the affidavit that Mr. Mkhwebane said he had in his possession. Now, I felt the need to respond to what I perceived to be Mr. Mkhwebane's attack on my and my son's integrity on the basis of what I knew was incorrect, particularly when he said the rich are protected and they steal from the poor and the unemployed. Now, it has been suggested to me that maybe I should have just said, I will inquire first before answering. Good answer, Bob. The president continues, but because I had some information about this relationship and there was this attack on something that touched on integrity, I felt I should answer immediately. But as it turned out, I didn't have all the facts. In the main, he continues, my reply to Mr. Mkhwebane's supplementary question was based on the information I had at the time, and it is against this background that I reasonably made the assumption that the alleged payment was related to advisory mandate that my son's company had signed with African Global. In paragraphs 33 to 35 of her answering affidavit, the public protector then says the following, page 773, Tsepo. paragraph 33, from paragraph 33, and just go up to see where it starts so we can show the members the heading table. 32. Here she's dealing, this is the PP's affidavit, and she is dealing with the president's reply to, and she says the president's reply to the above supplementary question and the facts that surround his reply revealed that such reply was in fact misleading. As I show below, this is evident from his own account that he sets out in his letter to the Speaker of the National Assembly, paragraph 33. I point out below that some of the facts that were relevant in my conclusion that the President misled the National Assembly in the manner in which he dealt with Mr. Mkhwebane's supplementary question. My finding in this regard is not malicious, but a statement of fact, which is borne out by his own correspondence to the Speaker of the National Assembly, in which he concedes the falsity contained in his answer. I also point out that the President was under no obligation to provide an immediate answer to a supplementary question. Instead of furnishing the National Assembly with information that amounted to misleading it, he could well have postponed his reply. It's important to note that in his response to the supplementary question raised by Mr. Mkhwebane, the PP responded as follows, and the PP there sets out the President's response. Go down, Seppo. She says, what's clear from the above extract is that the President was familiar with the issue raised by Mr. Mkhwebane. Not only was he familiar with what the issue was, he had actually specifically inquired about it from his son. He had even seen a contract that related to the payment referred to by Mr. Mkhwebane. In this regard, he had satisfied himself that the payment to Mr. Andile Ramaphosa was legitimate and related to services rendered by Mr. Andile Ramaphosa's company to Bosasa. In fact, more light is shed by Mr. Bejani Chauke, the President's special advisor in this regard. In his affidavit filed with the Office of the Public Protector, he confirms that indeed the President is correct that this issue was brought to his attention some time ago. The PP then cites what Mr. Bejani Chauke stated. And she says clearly, when the President stated that the matter had been brought to his attention some time ago, he referred to his conversation with Mr. Chauke, as he alleges. In September 2018, the President became aware of the issue raised by Mr. Mkhwebane. That much is apparent, and he understood what the issue was. And the PP, what the PP says is of relevance and in the paragraphs that continue until up until paragraph 49 of her affidavit. Go down, Seppo. So the PP is apparent from the contents of these paragraphs that the PP disbelieved that the President's response was in the heat of the moment. In paragraph 50, she says that the certainty and sanctimony accompanying his, that is the President's, his answer is not consistent with the claim that such an answer was a result of the heat of the moment. Instead, it is a well-calculated and considered answer with undertakings of steps the President would take if the facts revealed that his son was less than candid when he assured him that everything was above board and the 500,000 was a payment in terms of his contract with Bosasa, a copy of which the President had seen. The PP indicated her reasons for disbelieving the President in paragraph 137 of the same document, Seppo, page 822. Paragraph 137. Where she said that I found that the allegation that on the 6th of November 2018, during questions session in Parliament, the President deliberately misled the National Assembly is substantiated. And she sets out her reasons from paragraph 137.1 onwards, where she says that the President's heat of the moment response is concerning because parliamentary questions are an important means used by members of Parliament to ensure that government is accountable to Parliament and through Parliament to the people for its actions. She continues in paragraph 137.2 when she says that the President's provocation by the question from Mr. Maimane cannot justify giving poorly prepared answers and creating a risk of misleading Parliament, as was done in this case, that his answer was untrue. She says that his answer was untrue is common cause, that he did not give it immediately, that he did not have to give it immediately is also common cause. The President is the head of, as the head of state and the epitome of the Constitution, should have acted with restraint and not allow Mr. Maimane's questions to affect his demeanor, as he had stated in his response, that he had felt attacked and that he had to defend himself and his family. As already stated, the PP continued in her affidavit in paragraph 138. From the question Mr. Maimane posed, there are at least two issues that ought to have sparked concern to the President. The first is that Mr. Maimane was specific, that monies were transferred to a trust account called EFG2 for the benefit of the President's son. The second is that monies were transferred on 18 October 2018 prior to his son's company, Blue Crane Capital, signing the advisory mandate with African Global Operations. The President's heat of the moment response is of great concern. The heat of the moment cannot justify the response that the President made in Parliament. The PP then further stated her view in the application for leave to appeal at paragraph 45. Page 149, same document. Yeah, this page reference can't be right. 1149, so but did you get that? No. Go to paragraph 45. It's not right. No. No. Application for leave to appeal to the Concord. One 1143. No. 1443. 1443. And then go to paragraph 45. Yeah. Of that affidavit. This is the PP's affidavit in her application for leave to appeal to the Constitutional Court, paragraph 45. Yes, thank you. As confident as he was when he stated his facts and confirming that the matter had been brought to his attention, he later realized that his falsehoods could not be sustained and reverted to Parliament with his purportedly correct version. The president responded to this. So the president's response, Tsepo, is in relation to this issue. Appears from paragraphs 95 of his affidavit. 1543, page 1543. 95. We'll return to the issue of the president's response later so as not to delay things, if that's okay with yourself, Chair. So, Tsepo, go again to the PP's affidavit, in which she reflects what Mr. Chauke told the president. Page 774. Yes. So start in paragraph 37. And we have referred to this reference before, where she says what's clear from this extract, referring to Mr. Pejani's statements, that the president was familiar with the issue that was raised by Mr. Maimane. Not only was he familiar with the issue, with what the issue was, he had actually specifically inquired about it from his son. He'd even seen a contract that related to the payment referred to by Mr. Maimane. And in this regard, he'd satisfied himself of the payments to Mr. Andile Ramaphosa was legitimate and related to services rendered by Mr. Andile Ramaphosa's company to Bosasa. And she continues in paragraph 38, and she continues in paragraph 39 of her affidavit. What the president was told by Mr. Chauke with reference to what the president knew is reflected in the PP, by the PP in her report. On page 42, Tsepo, of the report, paragraph 5.1.10.51. 42 of the report. .51. 5.1.10.51. Mm-hmm. 5.1.10.5. Go up. Yes, 5.1.10, 5.1. So what the president was told by Mr. Chauke with reference to what he knew is reflected on 5.1.10, 5.1. That on 5 September 2018, the president was informed by one of his advisors, Mr. Pejani Chauke, about a rumor that the president's son, Mr. Ramaphosa, had received a payment of 500,000 from AGO. In addition, the PP's report indicated at 5.3.10.20. Page 68. Wait. 5.3.10.20. Yes. This is what is indicated in the report of the PP. She says, Ms. Nichols stated that she knew President Ramaphosa for some, no. 5.3.10.20. Ms. Nichols also confirmed what President Ramaphosa had stated, that she had been the one who alerted him to the inaccuracy of his response in Parliament on 6 November 2018, because she had been the one who was responsible for opening the EFG2 trust account, as well as having facilitated the payment of 500,000 to the CR17 campaign by Mr. Watson into the account, and therefore knew all about it. Given all of this, an issue to be taken up with the PP, one of the questions that will arise with her when she does come before the committee is the evidence that she had before her to contradict what Mr. Chauke and Mr. Nicol told her in relation to when the president found out about the donation. We say that this is an issue that should be taken up with the PP when she does come, because it's not apparent from the report that she drafted in the matter what direct evidence she had to the contrary to show that President Ramaphosa knew that Gavin Watson had paid 500,000 as a donation to the EFG2 account. Carrying on with what the PP then stated in paragraph 34 of her affidavit, Tsepo, that's on page 773. Paragraph 34. My finding, she says, in her affidavit, my finding in this regard is not malicious, but a statement of fact, which is borne out by his own correspondence to the Speaker of the National Assembly, in which he concedes the falsity contained in his answer. The PP further states the following to the court in her affidavit at paragraph 137.2. Page 823. And 37.2. As this was read earlier, but it's worth mentioning what she says here, that his provocation by the question cannot justify giving poorly prepared answers and creating a risk of misleading Parliament, as was done in this case. That his answer was, she says that his answer was untrue is common cause, and he didn't have to give the answer immediately, is also common cause. Now that needs to be juxtaposed, in particular, the common cause, what the PP asserts to be common cause needs to be juxtaposed against what the president said. And we start here with what he said at paragraph 137 of the founding papers, his founding affidavit. Paragraph 137. Right at the top. 137. Sorry, Chair.
Yeah, you need to speak to Tsepo. She's not hearing you.
That can't be it. No. So the president says, this is precisely what I did. I corrected the facts. I corrected the facts. The public protector seems to believe that my correction of the facts was an admission that I had misled Parliament. This is preposterous. Further, in reply, the president then disputes that he had made any statement with the intention to mislead Parliament. And for that, Tsepo, let's go to page 1253. One, two, five, three. Paragraph 67. Yeah. Paragraph 68. So the president says, the public protector has on a number of occasions claimed that I admitted that I misled the National Assembly. And the latest instance of that claim is in paragraph 34 that we've just referred to of her answering affidavit. This is demonstrably untrue. I have never made such concession, whether in my correspondence to the Speaker or to the public protector. I cannot understand on what basis the public protector finds my clarification letter to the Speaker on 14 November 2018 to be a concession that I had misled the National Assembly deliberately or otherwise. So given these statements, given the public protector's assertion in her affidavit that these issues are common cause, and the contents of the president's affidavit where he deliberately disavows having made any statements that reduce these assertions to being common cause. This, we say, is one of the issues that ought properly to be considered by the committee in its deliberations as to whether or not on the papers these issues were common cause as asserted by the PP. In this regard, I'd like to refer first to what the High Court said in its judgment, and what the High Court found based on the legal arguments that were presented by the public protector. So we'll go to the High Court judgment, paragraph 51. Right. So for present purposes, paragraphs 51 to 55 are relevant, but I shall perhaps focus on 51, 52, 54, and 55, where from 51, the High Court stated what the public protector had said in her argument. It said the public protector points out that elsewhere in her report, she cites the correct text. She stated in an answering affidavit that insofar as she erroneously misstated paragraph 23A of the code, her error was immaterial. This is because, according to her, my finding is based primarily on the president deliberately misleading Parliament rather than inadvertently doing so. This is inconsistent with her final conclusion, which states in so many words that her finding was also based on an inadvertent misleading by the president. A further difficulty with the public protector's stance is that it simply does not explain her confusion in the first place. Even if she sometimes referred to the correct formulation of the code, she demonstrably remained confused throughout as to what the code said and what test was to be applied before she could properly find that the president had breached the code in this regard. In the view of the High Court, it is stated in paragraph 52, the president is correct in his submission that the public protector's confusion permeates her entire consideration of the issue of this issue. Her confusion is borne out by her ultimate conclusion, which is difficult to understand. Counsel for the president submitted that it was garbled. As best we can understand, the public protector appears to have found that the president misled Parliament either deliberately and inadvertently or inadvertently by answering Mr. Mkhwebane's question on the spot and not allowing himself time to go away and consider the question so that he could make a well-informed answer. So we'll go to paragraph 54. In her treatment of this issue, the public protector demonstrated a fundamentally flawed approach to the principles underpinning the question of whether the president violated the executive code by willfully misleading Parliament. It is to be expected of the public protector to proceed from the premise of the correct formulation of paragraph 2.3a, to understand what the test is that must be applied to determine whether there has been a violation, and finally to pronounce a conclusion that can be clearly understood and is in line with that test. Unfortunately, the public protector's approach to the issue in this case falls far short of this. Paragraph 55, the High Court held in this regard, the public protector's finding on the misleading of Parliament issue is fatally flawed due to a material error of law. For this reason alone, the finding warrants review and setting aside. However, there are further reasons for reaching the same conclusion. If we go now to the finding of the Constitutional Court, which concurred with the High Court on these issues. So we'll go to the Constitutional Court judgment, paragraph 55. The paragraphs that are relevant for the purposes of this point in the Constitutional Court judgment are from paragraphs 55 to 63. I will not read out all of them, but we'll just focus on the issues that the committee should draw its attention to. Paragraph 55, the Constitutional Court said when the former president drafted the code, he didn't lose sight of the fact that members of the executive are usually called upon to give answers to questions raised in Parliament in respect of matters over which they have no personal knowledge. He cautiously and deliberately framed the code in these words: members of the executive may not willfully mislead the legislature to which they are accountable. Plainly, this prohibition is narrow. Members of the executive are forbidden from willfully misleading the legislature to which they are accountable. In other words, for a member of the executive to breach the code, she or he must have given incorrect information with the intention to mislead the legislature. Incorrect information alone is not sufficient to constitute a violation of the code. Such information must be accompanied by the member's intention to mislead. The court went on in paragraph 57 and said a perusal of the public protector's report reveals that she seriously misconstrued the code. The court made this finding with reference to paragraphs 5.1.33 to 5.1.34 of the contents of the public protector's reports, which I will not read, but which are cited verbatim there in the judgment in paragraph 57. In paragraph 58, the court then went on to say that quite clearly this statement, being the statement in the public protector's report referred to previously shows that she thought that the code prohibited members of the executive from furnishing any and every piece of incorrect information, regardless of their state of mind and the objective they wished to achieve. To her, the acknowledgement by the president that he gave an incorrect answer was enough for the conclusion that he had violated the code. If the president, according to the public protector, wished to avoid giving an incorrect answer, he should have insisted that the rules of the assembly be followed, which would have afforded him sufficient time to answer the question and make a well-informed answer. This reasoning is not only devoid of a legal foundation, but it also reveals ignorance as to how information furnished to Parliament is gathered. The court went on to say that what is more concerning with the report is that the public protector changed the wording of the code by adding deliberate and inadvertent misleading of the legislature. That this is an addition is apparent from the statement quoted above. And those would be the statements, Chair, that were quoted by the judgment in paragraph 57. She states that the president's reply breached paragraph 2.3a of the code, the standard of which includes deliberate and inadvertent misleading. It is inconceivable that the sole word used in the code, willfully, could be read to mean inadvertent. These words carry meanings that are mutually exclusive. Willfully cannot include inadvertent. What was done by the public protector here exceeded the parameters of interpretation. The court continued in paragraph 60 to say that the public protector's report reveals that on the facts placed before her, she accepted that the president did not willfully mislead Parliament. This meant that he could not have violated the code. The public protector then changed the wording of the code to include deliberate and inadvertent misleading so as to match with the facts. Having effected the change in the code, the public protector proceeded to conclude that the president had violated the code. It is unacceptable that the public protector did what no law had authorized her to do. In paragraph 61, Chair, the court continued that it was the wrong approach adopted by the public protector here, which led her astray. Instead of evaluating the president's conduct against paragraph 2.3a of the code, she measured it against a standard that she had created. This is plain from her findings as recorded in the report. On the question whether the president willfully misled Parliament, the findings read, and here, Chair, the judgment quotes the public protector's findings in her report in paragraph 7.1 and its subparagraph 7.1.1 to 7.1.4, which I will not read, but which are cited in the judgment, after which the court then concluded in paragraph 62, Tsepo, that it was wrong. It was this wrong approach which drove the High Court to concluding that her finding on the issue whether the president misled Parliament was flawed due to a material error of law. And in paragraph 63, the Constitutional Court then held that the High Court's conclusion that the public protector's findings should be set aside on the material error of law point alone cannot be faulted. Finally, Chair, with reference to the oft repeated or oft referred to minority judgment of the former Chief Justice Mkhwebane, as was pointed out during Advocate Mpofu's leading of the PP last Friday, Advocate Bauer drew the committee's attention to the contents of paragraph 202 of the CJ's minority judgment, in particular because what tended to occur is that in all references to the CJ's minority judgment tended to not refer to the contents of paragraph 202, in which the former Chief Justice Mkhwebane said, sorry, Chair. Judgment 12. Judgment number 12. Paragraph 202. See? Mm.
Page 4 and 3.
Yeah. Good. Former Chief Justice then said the following in that paragraph, that there can be no doubt that the public protector was wrong in certain respects. For that, she deserves to be dealt with appropriately. And it is for this reason that I have to reiterate my support for Jafta J's assertion that she went overboard in making the supervisory order against the police, the National Prosecuting Authority, and Parliament. It was wrong of her to conclude that the president deliberately misled Parliament and to use willful and inadvertent interchangeably when the two are mutually exclusive. The same applies to aspects of her remedial action alluded to above that manifest some overzealousness. The Chief Justice, the former Chief Justice, does adopt a different reasoning to the reasoning of the majority for the errors, saying in the next paragraph, paragraph 203, that said, I'm also concerned about any notion that she somehow amended the code without authority. I think hers was more of giving a wrong meaning to a legal instrument than amending it. It bears noting for the committee that before the Court in this litigation, there was no case made out that the PP had invoked, had relied on the Nkandla judgment insofar as stare decisis is concerned and how the code was dealt with there. In this litigation, the CR17 Busasa litigation, this issue only arose later in the rescission application that was brought before the Constitutional Court. But that too is a matter that can be taken up during argument and or when the PP returns to the inquiry. So that brings me to the end of this section.
Chair, we now want to turn to the section dealing with the CR17 campaign specifically, and the findings of the High Court, which at paragraph 77 and 78 concluded in terms that Mr. Maimani's complaint was not about the CR17 campaign, and Mr. Shavambu's complaint similarly had nothing to do with the CR17 campaign. And to start us off with, Shepa, go to 31.7.5, the President's affidavit at page 44, 108. The issue is, although dealt with on the affidavits, relates to the sphere of competence extended to the public protector for purposes of investigating the CR17 campaign. And the President says in 108, I submit, therefore, that in terms of, maybe we should go up so that I'm not accused of misrepresentation. He notes what section 182 restricts the scope of the public protector's mandate to be to state affairs of the public administration, and that section 6.4 and 6.5 limit the jurisdiction of the public protector to matters involving the state, the public administration, or public affairs. This is apart from what the public protector has in the MIA, which relates to the code. And then he says, I submit therefore that in terms of section 182(1) of the Constitution and section 64 and 65 of the Public Protector Act, the public protector had no jurisdiction to investigate donations made to an ANC internal campaign and in the pursuit of political party activities. Those donations do not implicate the state, public administration, or public affairs in any manner whatsoever. They are donations made to the campaign. The ANC is a voluntary association. The relationship between the party and its members is private and contractual. And then it goes on. The public protector purported to investigate donations made to the CR17 campaign on the strength of the code. She is, however, plainly wrong in the interpretation of the law and has no jurisdiction to investigate the matter under that act or code. So if we then go we know that the male and guardian judgment is what the public protector says guides her in the investigations and relates to the, we will have to during argument deal with what the male and guardian deals with as the substance of that case being maladministration in the public sector, and that under the Public Protector Act, she can initiate her own investigations in relation to matters within the public administration, and that differs from an EMEA complaint where she is limited to investigating the complaint that is lodged. Otherwise, there is a jurisdiction difficulty. So the High Court held in this regard, if you go to the High Court judgment, paragraph 91, so what the judgment does, if we possibly go back to paragraph 88, it explains that the public protector's report and answering affidavit identifies the basis on which she claimed to have jurisdiction to investigate the CR17 campaign. She relied on her constitutional powers under 182(1), her further powers under the PPA, and in particular on sections 6, 4, and 7, a duty to investigate complaints under the Ethic Act, and on the nature of the complaints lodged. And her stance may be summarized as follows in 89. Section 182 of the Constitution gives her powers to investigate any complaint, any conduct, not merely any complaint. She has the power to determine from a complaint what conduct should be investigated. Section 6.7 further extends the power to permitting her to investigate issues on her own initiative. If there are issues, she has powers to investigate under section 6.4.5. He then in 90 explains the two complaints that she received, and she says, Mr. Mkhwebane's complaint included a concern about money laundering in relation to the payment by Mr. Watson. And according to the public protector, she could not ignore her duty to investigate this issue. She then obtained the bank statements associated with the CR17 campaign and investigated them. She was further concerned that these sums of money claimed to be donations created a situation of the risk of some sort of state capture by those donating such large sums of money. She was concerned about the manner in which the transaction was conducted in light of the complaint of money laundering by Mr. Mkhwebane. And then as the donations were made at the time when the president was the deputy president of the Republic, public protector held the view that he may have opened himself to a risk of conflict of interest under section 96 of the Constitution, specifically relying on subsection 2B, which is quoted in the judgment, that cabinet members and deputy ministers may not act in any way that is inconsistent with their office or expose themselves to any situation involving the risk of a conflict between their official responsibilities and their private interest. The court then goes further and looks in the next couple of paragraphs on the sphere of competence. Just scroll down slowly, Shepo. She explains, the court explains the wide powers, that the public protector has as well, that she cannot investigate a complaint that falls outside her sphere of competence. And it then goes and it looks at what is the meaning of state affairs in the context of that and extrapolating in relation to that. And the submission made that the CR17 and its funding was from private sources, not state. It says that the EFF made effectively common cause with the public protector in respect of this, and that the conduct of the CR17 campaign in accepting private donations was a matter of state affairs and fell under her powers. And then the court says at 96, one cannot give the concept of state affairs that it appears in section 182(1) of the Constitution so wide a meaning that it serves no purpose. The Constitution is a legal document. The jurisdiction of the public protector in a review application like this one is a legal question. Consequently, we must seek to give a concept legal meaning. It is not helpful to seek an answer within the broader realms of political science. The Constitution does not define state affairs, but it defines an organ of state, and it goes through that. And then go to 198 and go to 98, looks at that. Go back up. I'm going to skip that bottom part of 197. It says section 181 limits the public protector's competence to investigate conduct that occurs in any sphere of government. And section 40 describes government as being constituted by the national, provincial, and local sphere. Go down. It then deals with how the constitutional treatment of the different elements of the jurisdiction, and it concludes that the public protector's competence to investigate non-state or private bodies or functionaries exists only if the alleged improper conduct involves public monies. She cannot investigate any conduct she chooses simply because it is alleged to be improper, no matter how serious the impropriety seems to be. It is important to bear in mind that the jurisdictional issue is not whether the public protector had the competence to investigate the complaint against or the conduct of the president. The issue is whether her sphere of competence extended to investigating the CR17 campaign. It is common cause that the CR17 campaign was an initiative operating within the context of pending internal party political elections of the ANC. The object of those elections was to elect office bearers within the party. The funding raised by the CR17 campaign was from private sources in support of certain candidates, including the then Deputy President of the country being elected as office bearers. The activities of the CR17 campaign fell squarely within the constitutional rights of participating members under Section 19(1) of the Constitution, which provides. Go down. And then it sets out what your right is to be part of a political party and to participate, and it explains that. Go down further until it comes to paragraph 106, and it reaches the conclusion that consequently it did not fall within the sphere of competence of the public protector to investigate the CR17 campaign. In assuming jurisdiction to investigate, the public protector appears to have conflated the CR17 campaign with the president. She then assumed jurisdiction on the basis that he was the deputy president at the time that the donations were received. However, the mere fact that the president was deputy president of the country at that time did not catapult the activities of the CR17 campaign into the area of affairs of state and subject to the PP's jurisdiction. The paragraph then looks at the uncontested evidence before the court as to the broad-based nature of the campaign, and I'll take you in a while to that evidence. And then I just want to finish this. And then if we go down, it deals with some of that evidence explaining what the CR17 campaign is about. Go down. Right. And it refers to the uncontested evidence before the court in respect of that, making the conclusion that the important point was that there were donations to support the party political cause of some members of the ANC for purposes of the December 2017 internal party elections. And it says in 109, as once it is established that the activities of the CR17 campaign did not fall within the public protector's jurisdiction, it does not assist her to rely on her powers under Section 6(7) of the Public Protectors Act or the money laundering complaint. This provision and the complaint cannot create jurisdiction for her. She either has the jurisdiction or not. If she does not have it, then no matter how wide the powers might be, she could not use them to investigate the CR17 campaign. So what the public protector then concludes on the basis of the investigation of the CR17 campaign from the public protector's report is that the president exposed himself to a situation involving a risk of a conflict between his official duties and his private interests, or used his position to enrich himself and his son through businesses owned by AGO. And that we see at paragraph 11.2.1, right? And so, Chair, that takes me to what was the CR17 campaign in its nature. And I don't know if you want to take the adjournment now, because I'm in your hands, Chair.
You are in the hands of lunch for colleagues. It's now 1 o'clock. We'll pause for lunch, take lunch for 45 minutes. We'll be back at 1:45. Thank you. We pause for lunch.
Recording stop.
back. We just use the other 15 minutes to do some other work that might be of assistance to us. Thank you. We now resume and proceed. Over to you, Advocate Bauer.
Chair, I indicated that what I'm going to turn to is what was before the court in respect of what was the CR17 campaign. And for that, I want to go to page 22 of the founding affidavit at paragraph 50. 30 in the Busasa record, 331.7.7.5. Uh, 22. To paragraph 50. President sets out in detail what the origins, nature, and the purpose of the CR17 campaign is. And he explains it to be the CR17 campaign brought together like-minded individuals to support the renewal of the ANC and my candidature as the ANC president and many others for election to the ANC's National Executive Committee. The campaign had broad political objectives, including the unity of the ANC and the restoration of its values and character. Through its communications and messaging, CR17 sought to engage ANC members and supporters in political debate and promote organizational development and unity in the ANC, while the core audience that the campaign sought to reach were ANC members. The campaign also sought to galvanize an anti-corruption movement and presented a particular vision and policy outlook to the broader progressive community, including civil society, faith-based organizations, traditional leaders, business, trade unions, students, and the media. And then he refers to a media statement that goes out onto the newspapers that deals with what the CR17 campaign is all about. Just move on. He then goes to what the CR17 website describes the campaign to be. Go on. What the key messages is to build, renew, and unite. Then he goes to the broader political engagement. And then he says what has happened over the course of nearly a year in 55. There are various communications that take place. And he says that the CR17 was just as interested in the character of the ANC that emerged from the 54th National Conference in December 2017 as it was with who was elected to its leadership. It explains it in more detail. At 57, it points out what the genesis of it was through a number of phases. And then in 58, it deals onwards, which I'm not going to read out, with its operations, its campaign officers, its campaign manager being Mr. Chowki, the team of organizers, field workers go down. Down. The project manager was Ms. Spark. And then in 61, the president says, I did not generally participate in organizing, communications, administration, and security coordination of the campaign. I was consulted on a range of political and strategic issues and also received briefings. Go down. 62, it states, it was agreed to the extent possible I would not be directly involved in the solicitation of donations, and the general practice was that the details of donors and amounts contributed should not be shared with me. He then says, I attended several fundraising dinners where I outlined my vision for the ANC in the country. The campaign team generally consulted me on the invitation list for these dinners, and I was very occasionally asked for guidance on possible donors. Go down. It then sets out what the campaign framework was. Go down. The project manager, the political committee. Go down. The fundraising committee comprising of certain people, the organizing and the campaigns, the communication, the security, the finance, the administration and logistics, and the nature and extent of the campaign. Its offices was across the country, and its governance structure, specifically indicating who was on the fundraising committee and its objectives. It then pointed out, go up, sorry, let me just go back to 68. It then pointed out that it would be open for any individual who cares about the future of the ANC, the future of the country, and supports my vision and candidacy for president of the ANC and the election of an ethical leadership to the NEC to contribute to the campaign. The contributions were made to the CR17 campaign. The individuals who contributed range from active members of the ANC to non-members. It then goes on, points out that there were 80 directly elected positions in the NEC, and intention was to ensure that each of these positions were taken up by suitable persons by reference to the ethical and moral position and the general support of the ANC revival. Go down. And so he concludes by saying that based on all of what he set out above, it was clear that CR17 could not be the work of a single individual, nor exist for the benefit of a single individual. And he then points to the comprehensive response that he provided to the public protector, to which I'll go in a moment. So in 72, the president concludes that she had no authority to investigate the CR17 campaign, and in any event, he had no personal entitlement to the donations made to the made to the campaign, and no basis to declare them as his. There is therefore no factual or legal basis for the public protector's finding that the president was duty bound to disclose the CR17 donations. Now, the public protector deals with this at page 848. Paragraph 191. Same document. Um, 191. 848. So the contents of the affidavit in answer says, I've already dealt with the content of these paragraphs elsewhere in this affidavit, and one of the issues that we would raise is precisely the extent to which that is dealt with elsewhere in the affidavits. The content of these paragraphs are denied insofar as they are inconsistent with what has already been stated. I deny that I had no authority to investigate the CR17 campaign, and there are no factual or legal basis for the findings that the president was duty bound to disclose the CR17 donations. So the question arises as to whether it's a donation or a sponsorship, and the public protector then president, prior to the report coming out, when responding to a section 7I notice, deals with this from page 341 of his response to the section 7I notice that was served on him. So Annexure MCR 21 is the president's response to the preliminary findings that the public protector makes. And you will see that from paragraph 222 onwards, the president had put this information before the public protector as part of his response. He deals with it from paragraph 22 onwards, go down. Deals with the media statement, the website, the key messages. Bear in mind, this is the answer that is given before the report comes out. The moment of renewal in paragraph 27, specifically he deals with same submission that was made in the affidavit. 2018, he talks about the weekly newsletter that comes out, which covers organizational matters, policy issues, ANC history, amongst others. Go down. He gives examples of what the newsletter is all about. And paragraph 31, he looks at the campaign through the program to encourage ANC members to organize political discussions and events. And he says this goes back to it, that it took nearly a year to organize. And he repeats some of the submissions that is already on affidavit. Now, the Constitutional Court held in this regard. Paragraph 31. So you go to item number 12. Page 345. Page, paragraph 31. Constitutional Court refers specifically to the media statement that you see was before both the public protector and before the report and in the founding affidavit, and says the management of the CR17 campaign issued a public statement to the media which sought to clarify the matter. Statement revealed that the CR17 campaign was established to promote, among other goals, the candidature of Mr. Cyril Ramaphosa to the position of the ANC, one of the political parties represented in Parliament. The other objectives of the campaign was to restore the integrity and cohesion of the ANC, as well as putting South Africa back on the growth path. Plainly, these were activities of the ANC as a political party. It then goes on, and it deals with the same media statement cited that the president, who was then the deputy president of both the Republic and the ANC, had no close contact with the campaign. By design, those who established the campaign wanted to avoid conflict of interest. Although the president was invited to some fundraising dinners with potential donors, he was not exposed to information about donors, donations, and who had made them. When he answered the question on 6 November 2018, concluded the media statement, the president had no knowledge of the donation by Watson to the campaign. And then and if you go to page 354, this is the, let me go down. Are you in the judgment? Go back to 31.5.7. 31.7.5, yeah. Go to page 354. The president said to the public protector, I was generally not aware of the donations, except for his own donation, as well as the contributions of James Mutlatsi, Sifiso Dambengwa, and Donna Nicol. Those are the people who are on the fundraising committee or the finance committee who oversaw the campaign. So he says that to the public protector, and in paragraph 62, he says, various political donors were contacted by the fundraising team to solicit donations to CR17. Potential donors were asked to deposit their donations in either the EFG2 or the Ria Tender Trust, once the trust bank account was established in May 2017. All donations received by the Ria Tender Trust was assessed by Standard Bank and a CR representative in terms of the Financial Intelligence Center Act 2001. This was a regular exercise undertaken by the CR17 campaign. I'm going to come back to the individual donations made to the campaign as part of the evidence. What I want to deal is set the foundation on what the public protector referred to before this committee relating to the emails that she had obtained and the reference to the dinner. The public protector at 849, paragraph 191.4, go to 849. So just go right on top, 191.4. In relation to the averment that I put up earlier on, the public protector denied that the president was not involved in the solicitation of donations and that they had not personally benefited from them. Says the evidence contained in the record are clear in this regard. Right. And then if you go to the High Court concluded paragraph 71 of the judgment. If you go to number 30, you'll see paragraph 71 of the judgment. Not paragraph 30, sorry. Go to the High Court judgment is number 30 on your, you've got it open. Of the judgment, which you'll find on page, yeah, you got it. So essentially what the High Court found was the undisputed evidence of the president is that the reason why it was decided that he should be insulated from information about donations to the CR17 campaign was precisely to avoid him being placed in the position of possible conflict of interest. His uncontested version is that his insulation from the details of the financial transactions and donors to the CR17 campaign ensured that he avoided the risk that donors might subsequently expect some form of payback from him. There is no evidence to the contrary, nor is it an implausible explanation. On the contrary, it seems to have been a reasonable strategy to employ in order to avoid possible conflicts of interest. Right? The public protector disputed this, and I'm taking to paragraph page 782, paragraph 55. Right, go up. I just want to see what she says about the statement. So she looks at the media statement that has gone out in respect of this. I'll go down, sorry. Which was the media statement of the CR17 campaign management team. And then I want to come to 55. I think this media statement has been read to the committee. And this is the issues that she identified that caused the difficulty. One, that the evidence showed that there were monies that were transferred to the Cyril Ramaphosa Foundation. Two, that Mr. Watson was present at the fundraising dinner hosted by the president. And three, that on 17 November 2017, Ms. Nichols sent an email to the president regarding fundraising and events. Right? And then she then turns to the emails. Right? And so I want to then go to the emails. On the one hand, you have had the evidence that had been given directly by Mr. Chowki and Ms. Nicol and what the president had told you. And on the other hand, the public protector had referred to these emails. And so one of the questions that will arise with the public protector is how those bits of evidence was balanced to do that. And so you also know, based on what was submitted to you last week, that there is an act called the Regulation of Interception of Communications Act, and we will have to deal with that in legal argument. But the law regulates the interception of private communications in respect of emails, and it makes it unlawful for people to be intercepting private communications, including emails. Right? Now, before we turn to the content of the emails, President stated, and just go to page 220 of the affidavit at para 12. Right. 31 point, so go to page 220, para 12. Back in the supplementary submission. No, that one. Go to paragraphs 12 and 13. Right? The president says, I submit that the donation was not in return for any benefit received by myself in my official capacity, nor was it in order to influence me in the performance of my duties. Instead, the donation was received to support an internal political party election. And 13, he says, it is my humble view that there is a distinction between donations made towards a campaign fund for a political party, elective conference, and gifts and benefits received by members in their official capacity or in an attempt to influence the member in the performance of their duties. The latter two instances would reasonably be subject to disclosure and or prohibition. Right? So we know that there are two aspects of that came before the public protector anonymously. What we would have to canvass with her, because it's not clear, is whether it came together or not. The public protector stated, and if you go to paragraph 769, page 769 at paragraph 25. My office further received an anonymous complaint from a whistleblower on 28 January 2019. The whistleblower has however precluded from lodging a complaint in terms of EMEA, since the whistleblower was not a member of parliament. I have no obligation to expose the identities of whistleblowers simply because they have blown the whistle on the president. It would defeat the purpose of whistleblowing if my office were to do so. So we know that there's that. We also, so just give me a, the president says when he, I'm going to preface this and I'm going to take you to the evidence so that it makes more sense. The public protector says she relied on the emails as evidence to refute that the president didn't know about the donation from Gavin Watson, or that the donations had been made to the campaign. These emails are not specifically referred to in the report, nor are they specifically mentioned in the source documents, and they are attached to the Rule 53 record. So when the president files his supplementary founding affidavit, he refers to them. They're not specifically referred to in the 7-9 notice that goes out to the president. So the president then picks this up in his supplementary founding affidavit at page 494. Right. And go up, just to put it in context. Right. Go up. Go up. Sorry, I'm going to start at the beginning of this so that it makes sense. There's it. Various emails relating to the CR17 campaign. It says that item 36 in the record index is various emails relating to donations on the CR17 campaign, which appears on pages 309 to 316 of the record. That is a reference to the Rule 53 record, and you see that that is 7 pages. These are the emails on which the public protector relies to deny that I was not actively involved in the operational affairs of the CR17 campaign, and that I was generally not informed of the identity of the donors and donations made to the campaign. The president then relies on the rights to privacy, and he points out that this constitutes personal information and it's protected from disclosure. And then he says, I'm informed that the emails contained in Annexure 36, being those pages of the record, are from an @Alexio online email address, which was the CR17 campaign email address, and which contained private and confidential information of the campaign. The @Alexio online email address appears on all the emails that are contained in Annexure 36 of the record. I'm also informed that the members of the CR17 campaign did not release these emails to the public protector. and then provides a confirmatory affidavit from Ms. Spark. These emails are also not contained in the FIC report, and they were not supplied to the public protector by FIC, and I did not provide them to the public protector either. In the circumstances, these emails could not have been obtained, could only have been obtained unlawfully. So the legal representatives then addressed a letter on the 26th of August to the Deputy President, and they raised the provenance of the emails in that letter. And they specifically request the DJP to direct the public protector to provide metadata in respect of the emails in question, or of the emails which they were attached or through which they were submitted to the public protector. And it's then stated this will enable me to trace the source of the emails which relate to the private affairs of the CR17 campaign and to determine whether they lawfully obtained. The public protector is then called on to explain how and from whom she received the emails. And he says, but in any event, they are irrelevant, go down, because the public protector is not entitled to rely on unlawfully obtained evidence. And he then points out that these emails were leaked to the media before even the Rule 53 record was out, and he refers to 2 of the newspaper articles. There was some reference to these newspaper articles last year. He then says further, these emails were not raised in the notice. That's the Rule 79 notice, and first made an appearance in the report without affording me an opportunity to address them before the public protector concluded the investigation. The mere fact that what could be improperly obtained evidence had been used in the investigation is enough to vitiate the report. So that's what the President says in the supplementary founding papers before this court. The public protector answers at 8:53. Go up. Go further up, sorry. We're looking for the odd paragraphs. But we are just go further up. Give me a second, let me just find the reference. See the odd paragraph here. Sorry, it's much further down in the answering affidavit. No, hold on, go down. Oh, it's a supplementary founding affidavit, but the President deals with it on. So we must look at the odd paragraphs that deals with the supplementary founding affidavit. I'm in the wrong document. Just give me a second. It is page 853, go down. Just look at that, 86. I think that's, it's one, start at 193. Right, which deals with 86 to 97. So they sets out the law. Right. Down. Right, there's it. 195.4 is the first denial. I deny that the President was not given an opportunity to respond to the allegation that he was aware of the campaign reports and donors. The Section 7 I notice clearly envisages this. I deny that I was duty bound to share evidence with the President during my investigation. So this is a response to that as the first to do with that. And the, just so the public protector further deals with the emails. Jay, just if you give me a minute, I would be misleading the committee if I didn't take them to where the public protector deals with the emails in our answering papers. And we've just seemed to have lost that reference. At paragraphs 83 to 90. Yeah. Paragraph 210. This is what the response is. It is telling that instead of denying the contents of the email, the president complains about how I obtained the emails to which I refer. I received many documents from anonymous whistleblowers. These emails were provided to my office anonymously and in hard copies. It is for that reason that I have no metadata in respect thereof. That is why I raised the issue whether this was an additional anonymous submission or whether that come with an anonymous complainant in the first instance, because it's not quite clear. The public protector then says, even if I knew the identities of these whistleblowers, I have an obligation to protect them. And she then denies that she obtained the emails unlawfully. We would have to argue, depending on what authentication the public protector provides to us in respect of the emails, whether there is a issue to be made about whether they've been lawfully provided to the public protector or not. So that is one of the questions we would have to ask the public protector. Go down. And that's what is being said about the if we go back to the report, right? If we come back to the report, if you go to the report, Shepo, it's page 132 of the report, paragraph 5.2.26. Now, the report states, I have evidence, furthermore, I have evidence which confirms regular updates to President Ramaphosa on the operations of the CR17 campaign by the campaign managers. We have not found the evidence that the public protector relies on for purposes of these regular updates in the record. So that would be something that would further need to be traversed. His directives to them about payments of the money into the CR Foundation, as well as being asked by the campaign managers for him to speak to certain donors. So that's what we have in the report. The president had indicated that he had not had, well, we saw what the president had indicated to do that. We were just to test this, we were taken to 2 newspaper articles in conjunction with these emails that had been provided, that was provided to the committee last week. Shepo, if you go to um, 35.7 point go to bundle H. It's the News 24 article. 31.7. Right.
You find sample? Or you need your glasses?
It's page 502. Okay, let me just get that one out. We're coming to the money trail, so keep that one open if you found that money trail one. Hold on. It's one of the ones. It's 502. It's the, just see. Maybe it's referred to in the statement at 502, which is why I'm jumping. Let me just go check. Page 502. Yeah. It's sorry, it's on the record. My apologies. The 31.7.5, it's page 502. Right. Not a separate document. It is in the record that's before the court. This was before the court. Okay, right. So we see from the newspaper reports on this in August of 2019. And they say leaked emails from the heart of President Cyril Ramaphosa's successful 2017 ANC presidential campaign revealed the names of some of his potential donors and undermined the defense that Ramaphosa was kept at arm's length of his funders. News 24 is in possession of several emails from inside the Ramaphosa campaign that have been circulated among his political opponents and by anti-Ramaphosa accounts on Twitter in recent days. Chair, I'm taking the same line that was put to the committee. I'm not for a moment trying to rely on the accuracy of the newspaper articles. I simply want to put out what the newspapers did so that when we ask Advocate Mkhwebane what she did, then we'll know what was done. News 24 says we have verified the accuracy of these emails and understand that Ramaphosa's campaign managers believe their communications may have been illegally intercepted. And then it references what the emails is about, and then we go down. And it details some of these emails. To do that. I'm sorry, I'm looking for the Yeah, go down, sorry. Sorry, just stop there quickly. So what they have is they have two emails from Ramaphosa's longtime assistant and CR17 campaign manager, Donnie Nicol to Ramaphosa, and an email from Nicol's personal assistant to another manager of the CR17 campaign, Marion Spark, are included in the leak. Typed notes by Ramaphosa himself to what is believed to be his bank instructs a transfer of 20 million from a money market account to an account belonging to the reattended trust. The trust used as part of the campaign's finance machinery, right? And then it goes down and it sets out that email. And then it says, it is understood that this relates to a loan Ramaphosa made to the campaign, members of the CR17 campaign, express concern that the emails were obtained illegally, but they have not disputed the authenticity. And then it details what that the public protector spokesperson did not comment in dealing with it. Go down. And it points out what the emails have to say. Go down. I'm going to go to the emails in a moment. Right, so stop there. Right. So on one of the emails, it details that Mick Davis to coordinate a group from London, and there's a name that is written and provides a UK cell number, which turns out to be Davis's personal phone, right? She also requests that Ramaphosa calls the Max Steel founder to thank him for the money and ask for another 10 million, and News 24 attempted to reach Samson this week, but to no avail. But what News 24 did do was they contacted Sir Mick Davis, and he told him that he had never been approached by Ramaphosa or any member of the campaign. So this was a lead that, although it came out after the report, the question to be asked of the public protector is, having been provided with these emails, did you follow up on the leads that was given to you via these emails to ascertain the accuracy of the contents thereof, to do that? And then if you go further down, there's a further reference to an email. Stop there. Go up, you've gone too far down. There's other people that are mentioned in relation thereto, and then we go down. Ms. Nicol asked for permission to approach. Go further down. All right, where they detail more of this information on her list. Go down. Further down. Is under Greek connection. There's the last of the leaked emails was from a Mr. Nikolai, who had been described as a long-term supporter of the ANC. And his further connections are pointed out, and they then refer to an email to Nicol, which was forwarded to Ramaphosa's email address on November 12, 2017. Go down. And it refers to Stavros says the following would fund if we had a small cocktail party. I need to discuss diary with you. And then a list of names is provided as possible guests for a cocktail party, which News 24 established was subsequently held at the private residence in December 1st, 2017. And they then have a conversation with the HIP Alliance, who says that at times they raise funds for political, charitable, and other causes. And they confirmed to News 24 that the cocktail party took place with the assistance of Ms. Nicol in December 2017. The attendees were vastly different to that on the list of 7 November. At the cocktail, members from the Hellenic and other communities met with the now president and briefly discussed their concerns with him. The president limited his discussions to the issues of the day and made no mention of funding whatsoever. The HIP Alliance further reiterated its support for Ramaphosa and expressed concern that the emails may have been illegally obtained. Further indicated that the leaked emails contain no reference to a communication from Gavin Watson, which one sees from the emails that's before the court. So this gives rise to the question as to what did the public protector's own investigation reveal in respect of the emails. And also what the public protector's own investigations reflected as to who Donald was, that the News 24 people had identified as being the president's banker. The High Court held in this regard, if we go to the judgment, which is at paragraph 117. So you go to number 30 and you go to paragraph 117. In this regard, in a report and answering affidavit, the public protector discredited the president's version on the basis that the leaked emails showed that the evidence was untrue. In an answering affidavit, the public protector identifies the emails she relied upon in discrediting the president's version. They comprise 2 emails sent by Ms. Nicol within a space of 1 week in November 2017. They support the president's explanation of his limited involvement in the fundraising activities, in that they show no more than 2 instances in which, among other things, the names of potential donors were discussed with him. These emails do not constitute a sufficient basis for the public protector's rejection of the president's explanation of the CR17 campaign and involvement. Right. So that I'm not accused of misrepresenting it, the public protector, or the suggestion was made to this committee that this was but a sample of the emails that had been provided to the public protector. And the question then asks is, what were the contents of the other emails that had been provided to the public protector, apart from the documentation relating to the banking, which emanated from the Financial Intelligence Center that had been sealed because of by the Deputy Judge President. The CC then turns to this issue of the emails in paragraph 73 of each judgment. 73. The Concord judgment. So the legal issues in respect to these emails was whether they were legally obtained and whether the president had been given a hearing in respect to that. And the court says in it goes, having identified witnesses who were interviewed, the report set out summary from the evidence of each witness. These included the managers of the CR17 campaign. With regard to Ms. Donna Nicol, one of the managers, the report states. She also confirmed virtually all what the other 2 members of the fundraising campaign had mentioned. For instance, the precondition made to the donors that they should not expect any favors for having contributed to the campaign, as well as the identities and amounts pledged being deliberately concealed from President Ramaphosa. Despite acknowledging that the campaign managers corroborated one another in the oral testimony, the report reveals that the public protector preferred evidence in the form of emails, which indicated that the president had played an active role in the affairs of the CR17 campaign. On this issue, the report reads, notwithstanding the unanimous statements by the CR17 campaign managers to me that it had been agreed that the identities of the donors and the amount donated by them should not be disclosed to President Ramaphosa, evidence adduced has revealed the contrary. Evidence adduced in a form of emails, invitations, and instructions confirm that President Ramaphosa was constantly informed of the activities of the CR17 campaign by the campaign managers, whereupon his advice and approval on specific matters would from time to time be sought. I have therefore established that in addition to having met with the potential donors during the banquet functions where he delivered keynote addresses, evidence further confirms that President Ramaphosa had had further and broader interaction with the donors, some of whom he knew very well. Apart from those emails which suggest that the president was more involved in the affairs of the campaign than the managers testified, there is no other evidence that linked the president with the campaign. The question which the Public Protector's report does not address is how the divergence between the managers and the emails was resolved. It appears that the Public Protector simply chose the emails over the manager's oral testimony, which he disregarded. This was inconsistent with the principles laid down by the Supreme Court of Appeal in Mail and Guardian, the decision to which the report refers. That decision affirms that the objective of investigations by the Public Protector is to discover the truth. Where the investigation yields disparate pieces of evidence which do not fit into place, the Public Protector must continue digging until the true picture emerges. As Newton observes in that case, and then there's the quote from the judgment that says, his or her function is to weigh the importance of otherwise of the information and, if appropriate, to take steps that are necessary to determine its truth. And maybe I shouldn't not read the first sentence, which says the Public Protector has no place summarily dismissing any information. 77, Mail and Guardian explained that the duty of the Public Protector is not only to discover the truth, but is also to inspire public confidence that in each investigation the truth has been discovered. Where the evidence is inconclusive or diverges, the Public Protector is obliged to carefully evaluate it to determine the truth. At the end, she must be in a position to say that the truth has been revealed. Here, the truth which the Public Protector was seeking was whether the President had personally benefited from the C-17 campaign donations. She has failed to discover this. The manager's testimony was to the effect that he did not benefit personally. But even if this evidence was to be rejected, there is no evidence that established a personal benefit. The emails on which the Public Protector relied simply showed that the President was more involved in the affairs of the campaign. This is not the same as receiving personal benefits. Moreover, the Public Protector could not disregard the evidence of the campaign manager solely on account of the emails that diverge with that evidence on the involvement of the President in the campaign's affairs. Instead, she was required to evaluate those witnesses' credibility and the reliability of the testimony on the one hand, and the authenticity and reliability of the emails on the other. And she should have also tested each version against the probabilities. When the versions placed before the Public Protector diverged in some of the relevant issues, she could not without more prefer one version over the other. The truth is established by facts, not one's preferences. In the circumstances, the duty of the President to disclose under the code was not triggered. On the basis of the uncontroverted facts, he did not personally benefit from the donations made to the CR17 campaign. Under the code, the duty to disclose is activated only once a benefit is given to a member of cabinet in his personal capacity. However, in argument, the EFF submitted that the President could not avoid disclosure by willfully remaining ignorant of donations made to the CR17 campaign. The submission misses the point. The issue is not whether the President deliberately kept himself ignorant of matters he was required to disclose. Instead, the question is whether there was proof that he personally benefited from the CR17 campaign donations. The EFF did not point to any evidence on record which established that the President benefited in his personal capacity, because such evidence was not placed on record. It does not exist. Go down. Without proof of that kind, it cannot be said that the President failed to disclose benefits he was under a duty to disclose. It bears emphasis that there must be first a benefit to a member of cabinet for him to or her to be obliged to make a disclosure in terms of the code. In the absence of proof of a personal benefit to the president, the High Court concluded that he did not fail to make a disclosure. In the entire report, the public protector has not even once referred to any evidence that indicates that the president's benefited personally from the CR17 campaign donations. The absence of such evidence was expressly raised in the representations made by the president in response to the interim report, and then that's detailed. Right? And while I'm on the subject, we just go to paragraph 128, because there the court deals with the president's complaint about being afforded a hearing in respect of the emails. 128. The president had complained that the emails on which the public protector relied were not disclosed to him, and that he was denied the opportunity to make representations on those emails. In his supplementary affidavit, the president stated, furthermore, these emails were not raised in the notice and first made their appearance in the report without affording me an opportunity to address them before the public protector concluded the investigation. We've already dealt with the other part. In an answering affidavit, the public protector does not dispute that the emails were not disclosed and the president was not afforded a hearing on them. She responded in these terms to the relevant allegations, and I've taken you to what the public protector had said in respect of that earlier. And the court then goes on in 130. While it may be true that the public protector had lawfully obtained the emails and was entitled to have regard to them during the investigation, she was under a legal duty to disclose them to the president and to afford him the opportunity to counter them if he was able to do so, or that he makes whatever representations he may have wished to make on the emails. It is a basic principle of our law that if a decision maker is in possession of information that is adverse to the person against whom a decision is imminent, that such information be disclosed to the person concerned and that he or she be given the opportunity to deal with that information. Our jurisprudence shows that the decision based on adverse information, which was not disclosed to the affected person and in respect of which that person was not heard, is fatally defective and ought to be set aside. Hence, the public protector based the crucial findings on the emails which were delivered by anonymous persons at the office without disclosing them to the president and affording him the opportunity to make representations. Notably, the authenticity of those emails was not established. In relying on them in the circumstances of this case, the public protector violated the Audi principle, and the findings based on the emails must be set aside. So, Chair, in argument, one would weigh up what he said to the court in the affidavits versus what he said to this committee in the written and oral representations. And if we go to let's not forget about the Chief Justice, so that I'm not accused of misrepresenting or not referring to the Chief Justice.
We mean the former Chief Justice.
Former Chief Justice.
I think Advocate Mkhwebane is helping us there, so that we properly refer to them. Because once we just continue saying the Chief Justice, it's like we don't appreciate the existence that there's a new Chief Justice. But go ahead.
The former Chief Justice deals with the paragraph 185. Same judgment we're in. I may have misunderstood the evidence last week, so it would need to be clarified. There is this whole question of a second Audi being given on the question of remedy, which the public protector addressed the committee on extensively. But this relates to the emails and not the question of a second Audi on remedy. To deal with this. The public protector should have afforded the president the opportunity to confront the contents of the emails that vitiate the version of the president and his campaign managers. It is concerning that she too, like the president, chose not to address the central feature of the concern raised, why she did not hear the president's side of the story before she finally relied on the emails. This is what the Audi principle demanded of her. But the president has taken us into his confidence and shared with us the views he would have expressed to the public protector regarding the emails had he been afforded the opportunity to do so. Chair, we will address you on argument on the value of evidence given after the impugned decision has been taken during legal argument. Right? Okay. So the other bits of information that the public protector relied on was the question of a dinner. The evidence that was put forward was that Gavin Watson had indicated that he had attended a dinner. So together with the emails, the president must have known he was a donor on the CR17 campaign, right? And if we take it what the president had said in his section 1779 response first at page 254. Same document. No, that was a judgment, eh? 31.7.5. 254. Go down. 52, 56. Let me just see what this document is. I might have misrepresented the document innocently, inadvertently. Go down. This is the transcript of the interview. This was the meeting. This was the meeting where the public protector takes the president through his section 79 notice. And if we go to page 256, stop quickly on the third line. And the key issue here is that we have established that you have hosted those dinners which have been organized for the donors where you address them, and therefore my preliminary review is that you actively participated in the campaign process. But then again, you'll remember section 96 of the Constitution is very clear that you shouldn't expose yourself to the risk of a conflict of interest. So the proposition is that the participation in the campaign in the dinners exposed the president to a risk under section 96 of the Constitution. And then at the CR in the report, in the report at paragraph 9.3.10.9, that stated, it's page 293 of the report, but my references is not the same as yours. So it would go down to the bottom of the report. No, it's go to paragraph 9.3.10.9. Sorry, Shipo. Go up to 5.3.10. It's got to be in the evidence. My apologies. Point 43. This was the evidence presented by Mr. Gavin Watson. Go down. So it starts on page 5.3.44 and go down. Yeah. Where he confirms that he had donated. Go down. And then he says in 5.3.10.48, Mr. Watson confirmed, although he did not attend all the dinner functions organized by the campaign managers, he was present at the one which was hosted by President Ramaphosa. Now, if you, Mr. Watson answered certain questions in writing on an affidavit. If you go back to the record, because the version that's attached to the reply in it, go to page 320. Right, these were the questions that were posed to Mr. Watson. Go down, and these were posed in a letter by the president's legal representatives to Mr. Watson. And the question is at 3.7, which says, did you attend the back to school dinner in 2016 or 2017, at which there were approximately 1,000 guests of the Adopt a School Foundation? If so, what did you wear to the dinner? School uniform was mandatory. Were you sitting at the sponsored table, and have you attended a CR17 fundraising dinner? That's at 3.7 and 3.8. So, Mr. Watson then responds to that on the cover of an email, which you see at go down at 3.23, right? 3.323, right? This is the letter under which it goes, and it says here, find Mr. Watson's affidavit. And you will see that the affidavit comes on the 12th of July. Go down. The actual affidavit, and we go to 3.7. Add paragraph 3.7, so just right. Stop. And he answers the question, I wore casual clothing when attended the function mentioned herein. And in paragraph 3.8, he says, I did not attend the CR17 fundraising dinner. Which one doesn't see from the body of the summary of Watson's evidence, but you see it from the letter, which is included in the report. So the one dinner that he tells the public protector he attended, he informs them in his affidavit what it is about. There is a further dispute, Chair, about Watson's affidavit in respect of the extent to which it relates to the Dlamini Zuma campaign, but for purposes of this now, I'm not going to deal with it specifically. One would need to lead evidence in that respect, and I don't want to be doing that at this juncture. I'm going to now hand over to Advocate Mkhwebane to deal with the power to investigate that comes up as to the power to investigate the CR17 campaign, and then I'm going to turn to the money question. That the committee had evidence on the 1 billion, 1.2 billion scenario.
What you? I've got Mr. Mkhwebane.
Thank you, Chair. So Chair, and members will recall that during her evidence, led by Advocate Mkhwebane explored at length with the PP her investigation of who donated money to the CR17 campaign. And this was the primary focus of the public protector's investigation. The question in relation to this aspect, Chair, and this will form part of the legal arguments that will be before this committee, The question is the issue of whether or not the PP had the legal competence to investigate the affairs of the CR17 campaign. The courts have ruled on this question. We will say during legal argument that their findings constitute a binding precedent. The first court to look at this was the High Court, and it concluded that the PP did not have the legal competence to investigate the issue. Tsepo, can you go to the High Court's judgment at paragraph 120? Thanks, Tsepo. So Chair, the High Court, when starting to look at the issues, said at paragraph 120, the public protector's finding that the president received direct financial sponsorship through the CR17 campaign was based on her conflation of that campaign with the president. What she had before her was a full explanation as to how the CR17 campaign spent the money that it raised. This showed that it funded the entire broad-based CR17 campaign. There was no evidence that it was used to pay the president's expenses. On the contrary, the president himself contributed to the CR17 campaign, as did many other ANC members. The public protector has not identified any evidence nor facts to substantiate her conclusion that he received direct personal sponsorship through the campaign. It continued, the High Court continued in paragraph 121, the whole of which is relevant, but I'll start my reading from about the middle, where the court said, from her report, it appears that the public protector was concerned about transfers from the CR17 campaign accounts to the Cyril Ramaphosa Foundation. However, the facts before her clearly established that neither the president nor his family were beneficiaries of the CRF, which is the foundation. Neither did they receive funds from it. The public protector had no contrary evidence at her disposal. The High Court went on further, Chair, but Tsepo, go to paragraph 208. Yes, start paragraphs 208 and 209. Like any official required to make pronouncements to the public protector must surely strive to be as clear as possible in her findings. Her reasoning on the disclosure issue was muddled and difficult to understand. It failed to explain to the public why she had found that the president of the country had willfully breached the duty of transparency established by the code. Indeed, her conclusion inexplicably found that at the same time, the president had also inadvertently misled Parliament, sowing further confusion. As counsel for the president pointed out, although the public protector received full representations from the president, she did not engage meaningfully with them. She did not deal with the explanations as to how the CR17 campaign was structured and how it functioned. She did not engage with the explanations that the transfers between the various accounts were aligned with the very structure of the CR17 campaign itself. Instead, and despite this evidence before her, she persisted with her thesis that there were reasons to suspect that the CR17 campaign was involved in state capture of some sort, and that a prima facie case of a suspicion of money laundering had been established. She recklessly ignored the evidence at her disposal, which pointed to the opposite conclusion. In doing so, she breached her duty to continue to approach every investigation in an open-minded fashion. So So members will recall that the president succeeded in the High Court in having the public protector's decision to investigate the CR17 campaign set aside. The president had argued in the High Court that the affairs of the campaign fell outside of the jurisdiction of the public protector. In the Constitutional Court, the public protector and the EFF sought to overturn the decision of the High Court. So turning to the High Court judgment, Seppo. No, wait, item 12. Yeah. Item 30, yeah.
No, 12.
It's 12. Item 12. This was the High Court. I want to go to the Constitutional Court. All right. Paragraph 38. Yes. Paragraph 90. Mhm. No. 90. 90. So the matter then went to the Constitutional Court, which said in paragraph 90, the contention that the president personally benefited from donations made to the CR17 campaign because one of the campaign's objectives was to promote his candidacy to becoming president of the ANC. A step towards becoming president of the country is at first blush attractive, but it cannot withstand scrutiny. The contention rests on a number of assumptions that are without factual and legal foundation. The court then began to lay out what some of those assumptions were, starting from paragraph 91, when it said, in the first place, the code does not apply to matters which are not state affairs like internal party elections. According to Section 2 of the Members Act, the objective of the code is the promotion of an open, democratic, and accountable government. And members of cabinet are obliged to comply with the code when performing their official responsibilities. In an attempt to overcome this obstacle, the argument seeks to link the election of the president of the ANC to being president of the country. But this falters at the starting line. In our multi-party system, being president of a political party is not a guarantee to being president of the country. Under our constitution, there can be only one president at any given time. This means that a number of party presidents cannot be president of the country. Moreover, the constitution tells us that the president of the country is elected by the National Assembly. The National Assembly consists of women and men elected by voters in terms of an electoral system, but it is the political parties themselves which contest elections, and they alone decide who among their members would become members of the National Assembly. Representation of each party in the National Assembly depends on votes received by them. Therefore, even though a president of a political party may wish to be president of the country, and his or her party makes him or her a member of the National Assembly, he or she may not succeed if the party failed to get majority votes at the elections. Even if it did get a majority of votes, it would still depend on whether members of the party wish to vote for their party president. There are many variables that occur before one is elected president of the country. The contention overlooks all of this. The court continued, and I'll just read out, Chair, paragraphs. This entire portion is relevant from paragraphs 90 to 97. But for present purposes, I'll read also paragraph 93 and then 95. 93, the court said, but even if it were to be said that there was proof of a personal benefit, the public protector's finding was fatally defective. She was plainly not authorized to investigate the issue whether the president personally benefited from donations made to the CR17 campaign. The condition precedent for undertaking such investigation did not exist. Section 4 of the Members Act mandates the public protector to investigate violations of the code only if there is a complaint by one of the persons listed in the section. Here, the complaints received by her did not require her to investigate the president's failure to disclose benefits derived from the CR17 campaign donations. Paragraph 95, Tsepo. None of the complainants had asked the public protector to investigate the president's failure to disclose benefits he derived from the CR17 campaign. The only reference made to donations in the complaint by the leader of the official opposition was in relation to the issue of money laundering. Evidently, the complaint was not that the president is suspected of having laundered money. The complaint was that the donation made by AGO passed through several intermediaries that gave rise to the suspicion of money laundering. But the evidence by the donor and the person who made the payment quashed the suspicion. In our law, where the exercise of public power depends on the existence of certain conditions, such power cannot be validly exercised in the absence of these conditions. This simply means that here, the public protector purported to investigate the president's failure to disclose benefits without the existence of a complaint. Consequently, her purported investigation of this issue and the remedial action she took were invalid because the investigation was unlawfully undertaken. The Constitutional Court then concluded, I'm not persuaded that any of the conclusions reached by the High Court should be overturned. So, Chair, the Constitutional Court further held as follows from paragraph 99 onwards regarding the public protector's competence to investigate the affairs of the campaign. It characterized the question as a legal question that must be answered with reference to the empowering provisions of the Constitution and relevant legislation. Section 182(2) of the Constitution provides that in addition to powers listed in 182(1), the public protector has additional powers prescribed by legislation. The Public Protector Act and the Members Act constitute legislation contemplated in the Constitution. In paragraph 100, somewhere in the middle, go down, Tsepo. At the end of paragraph, somewhere in the middle, the court, with reference to the additional powers of the public protector and the provisions of the Public Protector Act, the court said evidently none of the powers flowing from Section 6 of the Public Protector Act cover the affairs of the CR17 campaign. For its part, the Members Act authorizes the Public Protector to investigate alleged breaches of the code only Even so, the public protector may undertake an investigation only after receipt of a complaint envisaged in Section 4 of the Members Act, although there have been alleged breaches of the code, none related to the general affairs of the CR17 campaign. In fact, there is no mention of the CR17 campaign in the complaints received by the public protector. Accordingly, the Members Act 2 did not empower the public protector to investigate the affairs of the CR17 campaign. The court then said this leaves Section 182(1) of the Constitution as the only possible source of the public protector's power. It then cited the contents of Section 182(1) and said, the court said this provision empowers the public protector to investigate any conduct in state affairs or in public administration. This means the scope of the power is limited to state affairs and affairs of the public administration. There can be no doubt that the CR17 campaign was engaged in the affairs of the ANC, which is a political party. The fact that it was the ruling party at the relevant time did not make it a part of the public administration. But in this court, the EFF argued that as a ruling political party, the ANC undoubtedly influences the direction of the state. The Constitutional Court said, while this is true, it doesn't mean that the ruling party and the state become one entity. Ordinarily, political parties win elections on the basis of their policies and manifestos, and this occurs worldwide. And once they assume power, they promote the policies that won them the elections. But the bright line separating the party from the state remains intact. This is clear from the provisions of the Constitution, which establishes 3 branches of the state. In our system, political parties are represented in the legislative and executive arms of the state. It is a multi-party system. That is why various parties have members representing them in parliament. And sometimes the president does appoint members of opposition parties into cabinet. Representation in a particular body does not mean that the represented entity becomes part of the body where the representation occurs. In the middle of paragraph, just below the middle of paragraph 104, the Constitutional Court said that no public power applies to private and internal party elections. Third, the court said, in terms of the law, it is the political party that determines the list of candidates who would represent it in each legislative body. There is no law that obliges a party to put its office bearers on that list. Consequently, being elected to a position within the party does not guarantee those elected a place in state legislatures.
We can pause there for tea.
Yes, Chair.
Then we'll come back. Thank you.
How long is the break?
10, 15 minutes.
Thank you, Chair.
Thank you.
Recording stop.
very much. Welcome back from tea, colleagues. We proceed with Advocate Mkhwebane.
Thank you, Chair. So I was taking the committee through what the Constitutional Court said, and I think I ended off. So please put up that judgment. I think we were at paragraph 104 is where I last read. May I just point out, Chair, again, reiterate that here the Constitutional Court was discussing the competency of the public protector to investigate the affairs of the CR17 campaign, and it did so from paragraphs 98 of its judgment until its conclusion at paragraph 109. But I'll continue now with paragraph 107, Tsepo. Where the court says that what turns an otherwise private entity into an organ of state is the exercise of a public power or the performance of a public function. This is vital in determining whether a particular conduct amounts to a state affair. There can be no state affair without the exercise of public power or the performance of a public function. This is the dividing line between state affairs and private affairs. When a political party holds internal elections, it does not exercise a public power, nor does it perform a public function in terms of the constitution or legislation. Instead, it acts in terms of its constitution, which constitutes a contract between it and its members. Therefore, its affairs do not fall within the scope of matters to be investigated by the public protector under section 182(1) of the Constitution. The court then continued to discuss an aspect of the written submissions of the EFF, and it said in paragraph 108, in its written submissions, the EFF conceded that the High Court may have been correct in its interpretation of section 182(1) of the Constitution. But it argued that the jurisdiction of the public protector to investigate the affairs of the CR17 campaign was sourced from section 9(2)(b) of the Constitution. The court said there is no merit to the submission. This section prohibits members of cabinet from acting in a way that is inconsistent with their office or exposing themselves to the risk of a conflict between their official responsibilities and private interests. For this prohibition to be breached, there must have been a forbidden conduct by the member of cabinet. But more importantly, the court said in paragraph 109, the public protector's powers to investigate violations of section 96 is limited by sections 3 and 4 of the Members Act. There must be a written complaint about a breach of the code. None of the complaints submitted to the public protector referred to the affairs of the CR17 campaign, let alone that those affairs were in breach of the code. The High Court was correct in concluding that the public protector had no authority to investigate the affairs of the CR17 campaign. So apart from these legal issues, Chair, the President had answered or had responded to the issues raised by the public protector in relation to the CR17 campaign in his response to the section 79 notice during the course of the investigation, and this is part of the record. In addition to that, the President had also submitted a supplementary response to the PP with regard to the disclosure of donations to the CR17 campaign. Tsepo, can you go to the PP's report? No, paragraph 5.2.5.11. So here, Chair, I'm addressing the President's response supplementary response to the PP in regard to the donations of the CR17 campaign. His response is lengthy and it's incorporated in the report itself. I won't read it all. It goes all the way right up until subparagraph 5.2.5.22, but I will, all of that is relevant, but I'll just, for present purposes, read a few of the paragraphs, starting with 5.11.2.5.11, where the president said that he submitted that the donation was not in return for any benefit received by myself in my official capacity, nor was it in order to influence me in the campaign fund for a political party elective conference and gifts and benefits received by members in their official capacity or in an attempt to influence the member in the performance of their duties. The latter two instances would reasonably be subject to disclosure and or prohibition. Paragraph 13, right up to the moment of this donation, it could never have been the intention of the legislature to regulate donor funding for internal political party elections. It is clearly the intention of the legislature to regulate the provision of gifts and benefits to members in return for a benefit received by the member in their official capacity or in an attempt to influence the member in the performance of the member's duties. The donation relates to an internal political party election, and it has nothing to do with members in their official capacity or in the performance of their duties. I submit that this is a different arena, said the president. He continued in the paragraphs below that, in subparagraph 18, 52518, he said, I had no knowledge of the donation and therefore cannot reasonably be expected to have disclosed it when it was made, even if there was an obligation to do so, which there was not. In subparagraph 20, further down, Sepo, he says, I was neither required to disclose the donation, nor was I prohibited from receiving it in terms of paragraph 4.1 of the Code of Ethics, as it was not received by myself in my capacity as a member, and because the Code of Ethics does not apply to internal party political campaigns. Carry on to subparagraph 22, where the president then stated that based on everything that he had said above, I do not believe that in this matter I have failed in my duties and disclosed in my duties to disclose interests as required in the Executive Ethics Code. In essence, then, Chair and members, the Constitutional Court in relation to the issue of the competence of the PP, the power to investigate the donation to the CR campaign, this Constitutional Court rejected the Public Protector's conclusions for the reasons that I've articulated previously with reference to that judgment. It rejected the following conclusions of the Public Protector. One, that the campaign donations were a form of sponsorship. Two, that the benefits were of a material nature to the president at a time, of course, when he was the deputy president. It rejected the conclusion that the president was duty bound to declare such financial benefit. And it rejected the conclusion that his failure to do so was a breach of the Code of Ethics. Which brings me to the end of this portion, Chair. And I'm now going to hand over to Advocate Bauer.
Okay, thank you.
I want to take up the issue of the money trail, which is dealt with at paragraph 5.3.10.16, page 82 of the Public Protector's report. And for the convenience of members, some of it is repeated in the public protector's affidavit to the committee at page 278, 277 onwards, at page 619. And the public protector 5.3.10.60 on page 82. The public protector report reflected that there were large sums of money transferred by various benefactors into the EFG2 trust account for the CR17 campaign, and that it was disbursed by the attorneys to several beneficiaries, including the Ria Tender Trust, the Linked Environmental Services, and the Cyril Ramaphosa Foundation. So the evidence on this disbursement starts in the section where the public protector refers to subpoenaed bank records of the EFG trust account from the banks involved to do that. You were also shown, and we'll come to that in a moment, an article which appeared in the Mail and Guardian, which would be at 897, just for Shepherd's reference numbers, 31.7.17, that I will come to in a while, right? Yeah, which one? Yeah, yes. But for now, let me go to the founding affidavit as to what the president had to say about it at paragraph 71 of his affidavit, which is located in the 31.7.5 at you got it, Shepherd? Paragraph 71, which is at page 31. And it reads, comprehensive response was provided to the public protector explaining the finer details of the CR17 campaign. And I ask that my response attached here to marked MCR 21 be read as specifically incorporated in this affidavit. Despite all of that, the public protector determined to treat CR17 as my private chattel and as my damning findings and far-reaching remedial orders against me for failing to disclose as mine the donations made to the CR17 campaign. The public protector's approach in this matter is unfortunate and leaves a lot to be desired. She has no authority to investigate the CR17 campaign. In any event, I had no personal entitlement to the donations made to the campaign and therefore no basis to declare them as mine. There's therefore no factual or legal basis for the findings that I was duty bound to disclose the CR17 donations. And then we go to MCR 21, which is at 329. Yeah, go to 363. More in point, we know that. And we're going to go down to paragraph 104. Yeah. So what I'm going to do with this, right. Maybe just go back up, so a little bit up. Up a little bit more. We start at the EFG account. Right. So what the president does is actually go up to 92, 94. It's start of what the president says what the money was spent on. Right. CR17 funds were spent on a variety of items, and he lists them ranging from office rental, campaign, travel, salaries, monitoring, research, expenses at national and provincial level, mobilization and campaign activities. So that's the fund, firstly. Secondly, rallies and events across the country involving hiring, venues, travel, campaigns, support for ANC members attending branch meetings, leaflets, t-shirts, go down. Booklets containing campaign messaging, monthly budgets and expenditure reports were submitted to and approved by the Finance Committee. Therefore, the large sums of money referred to by the public protector were perfectly lawful, did not breach any laws, were necessary for the overall running of the campaign, and the payments did not constitute maladministration. No monies went to the president or his family. President, to the contrary, was one of the donors to the CR17 campaign. So, the public protector, and I'm not going to go to the report, I'm going to read out what the report says, and then you can see how the president dealt with it, because what is contained in the report is what is contained in the section 79 notice that was issued to the president. And so the public protector's report says, from the evidence received by my office, an amount of 191,482,227.43 was deposited into the EFG 2 ABSA trust account between 6 December 2016 and 1 January 2018. And 190,108,227 was transferred out of this account in the same period. So what the president does in his first paragraph, he details what's in his section 79 notice, and I'm reading to you what's in the report. So then the president goes and in his submissions he deals with, he explains this money, right? In relations to deposits made into EFG2, it should be noted that between 6 December and 1 January, 6 December 2016 and 1 January 2018, 182,143,862.85 was deposited into EFG2. This amount increased to 191,532,144.55 as of 29 January 2018. Therefore, the public protector's finding that 191,482,227.43 was deposited into EFG2 between 6 December 2016 and 1 January 2018 is incorrect. With respect transfers out of the EFG2 account, he first deals with it. Sorry, I'm going to let me not skip 100. It appears that the public protector may have considered the incorrect period when determining the above mentioned amounts. This inference is drawn on the basis that if the period between 6 December and 29 January 2018, as opposed to 6 December and 1 January is examined, there is only a 49,917.12 discrepancy between the amount that the public protector alleges was deposited into EFG2 and the amount that was actually deposited into the account. Go down. With respect to transfers out of the EFG2 account, the public protector alleges that 190,108,227 was transferred out of EFG2 between 6 December 2016 and 1 January 2018. This finding is also incorrect. And the president then sets out what the correct amount was that was transferred during the period and says this amount increased to 191,396,682.49 as of 29 January 2018. The conclusion reached is, therefore, the public protector's findings in relation to payments made into the EFG account from the EFG account between 6 December and 1 January 2018 are inaccurate. in her statement, if we go to page 617 of the Busasa record, you on the same in the document you're in. 617. Oh, sorry, that's the wrong page. It's paragraph 268. Paragraphs two. Hold on. I'm going to read you the paragraph and I'll ask Advocate Mkhwebane to find the reference so that I can give you the paragraph reference. It's paragraph 268 of the Public Protector's answering affidavit. It reads, we also had evidence which indicated that some of the money collected through the CR17 trust account was transferred to the Cyril Ramaphosa Foundation account, which belongs to the president. And at the president's affidavit, which you see at 357, in the document. Right, at paragraph 72 and 73, right? The president says, he explains what I've just told you about the CR17 campaign, having being reimbursed for certain arms death transactions. And he says, the president was not involved in any decision where venue and additional assistance was sought from the CRF by the CR17 campaign. He would not be involved in any decision such as reimbursement for services rendered by the CRF to the CR17 campaign. No payments made by the CR17 campaign to the CRF benefited the president personally in any manner whatsoever. And then he explains what the CR17 Foundation is about in the ensuing paragraphs. It was established in 2004 as the Shantuka Foundation to be a corporate social investment arm of the group that was changed to his name after the president divested from the Shantuka Group in 2014. It is an independent public benefit organization that aims to improve lives by creating opportunities through education and enterprise development. It has a vision to be innovative and effective agent for change, and explains what it's about. Importantly, he says the president and his family has never been beneficiaries of CRF, and in fact have been significant donors to the foundation. In aggregate, he has contributed close to 220 million to CRF. He initially set aside 5% of his shareholding in the Shantuka Group for two trusts that now forms CRF. These shares were realized when the president divested from the Shantuka Group. On becoming deputy president of the Republic, he also donated shares in other companies to CRF. He supports CRF's partner entities with donations for students and has also made donations to Adopt a School. And I'm going to read the part of the Adopt a School Foundation because that is the dinner which Mr. Watson indicated he attended, because it says that the Cyril Ramaphosa Foundation delivers on its mandate through 4 implementing partner entities, the first one of which is Adopt a School Foundation, which supports with the committed support of private sector partners, hosts annual fundraising functions since 2007, known as Back to School Parties, at which money is raised for disadvantaged schools. The KST, this is a collaboration between CRF and the Kagiso Trust, implements the district whole school development program. He then explains the education trust. Move on. The Black Umbrellas, and he says to date 359 million has been contributed by CRF and over 1 billion has been leveraged through its partner entities to programs that support development in the key focused areas. Right, so let's move on. A full explanation is provided to the public protector about the foundation. And the public and the president also tells the public protector at 356 at para 57. On 28 July 2018, the president deposited 1 million rand into the account of Reattend the Trust as a loan to the campaign. There is another paragraph 57. I think there's another paragraph somewhere later where he puts out that in total he contributed 6.2 million to the campaign and loaned it a further 31 million, of which he had only been refunded 21.5 million. We'll find the reference to that. Right, so he explains the Reattend the Trust. And in paragraph 80, page 360. Says the Reattend the Trust was founded by the fundraising committee of CR17 in 2017 to advance the social, political, and economic interests of South Africa as a whole, and to advocate for the establishment and maintenance of non-racist, non-sexist, democratic, ethical, accountable, and properly functioning social, political, and economic environments in South Africa. The letters of authority of the trust is provided. It was issued by the master, and they were mandated to receive donations that were made towards the CR17 campaign, and he provides the trust deed. It points out that no trustee, of which there are 4, shall be a beneficiary of the trust, nor shall any related person in respect of any trustee be a beneficiary. So he makes the point that he did not establish the Reattend the Trust, and there's no role in directing its operations, as these were done separately and independently of him. Right. Linked Environmental Services is described as a private company registered in 2008. It is independent of CR17. It offers a variety of services to the public and private sector, including but not limited to project management, advisory services, knowledge management and information technology services, and sustainable strategic planning services. The trust had concluded a service level agreement in 2017 with Linked for the provision of accounting, financial administration, budgets, payments, etc. I've gone through that already, and I've read that part of it to you. Right. Paragraph 86, it says the president had no involvement with Linked. He was not involved operationally in any decision related to the transaction between Linked and the Reattend the Trust. So then if we go to the president's affidavit at page 60, para 166, where he refers to the material errors of fact in the report as follows. Page 60, yeah. Page 166. In my response to the public protector, I alluded to all of the material errors of fact committed to the public protector. I refer to them as if they are specially incorporated herein, particularly sections 92 to 123 of my responses. And we've gone through most of them, if not all. In summary, the public protector misunderstood the flow of funds, miscalculated the amounts paid, double counted the same amounts in certain instances, referred to incorrect time periods, and misunderstood the relationships between the various entities. I'm advised that any decision by the public protector must be based on the accurate findings of fact. The report dismally fails this test. This is met by a response in the answering papers that says the following, and we go to very easy. Okay, just go to page 820, Shepo. Yeah, I want to go to paragraph 200. Okay, let's go to the stop. It says at paragraph 166, the contents of this paragraph are denied. I deny that the alleged errors are material errors of fact relevant to the issues at hand. I pause to mention that while the president alleges that he was never given Audi in respect of the evidence regarding the transfer of funds, his response to the Section 7(I) notice clearly demonstrates otherwise. The transfer of funds in and out of these accounts raises a suspicion of money laundering, and I'm entitled in law to refer the matter to the relevant authority for investigation. The president's response in respect of donations made by CR17 to the Cyril Ramaphosa Foundation, and that the Cyril Ramaphosa Foundation is a charitable trust that the president and his family have never been beneficiaries of, is a disappointing response from a head of state. He concedes that 5 million was paid to the Cyril Ramaphosa Foundation to help fund its own communications campaign to publicize its work in the areas of education and enterprise development. We would have to ask the public protector why it's a disappointing response. To 20.5, these paragraphs again highlight the technical issues the president raises in an attempt to avoid taking responsibility. I submit that the nature of the transaction lends itself to possible miscalculations, but this should not detract from the fact that there were suspicious transactions warranting further investigations by the relevant authorities. None of these technical responses from the president take away the fact that large sums of money were moving from different accounts and intermingling with funds that were already in those accounts. So that's the public protector's response to the figures that were put into the Section 7(I) notice. It's not denied, and the report does not reflect that it deals in any way with the figures that the president reflects in his response to the Section 7(I) notice. If one has a look at page 619 of the affidavit before this committee, it reflects the same figures that the president had indicated was incorrect. And if one takes a simple addition of the totals, you would get close to 1 billion or 1.2 billion, unless you actually realize that you're using the same money transferred from one account to another. There were several intermediaries, which is the complaint. This is the phraseology of a complaint by Mr. Mkhwebane in his complaint, in his EME complaint. I'm just wanting to deal with the phraseology, several intermediaries while we on the subject of the flow of money. We know, and we've shown the committee, that what the money did from Mr. Watson's private account, it went to Miyota Trading to EFG. That's one intermediary. Right? And Mr. Watson informs the public protector how this came about. One doesn't see this in the report, one sees this in the transcript of the interview with Mr. Watson. So if we go to 993, lines 25 to 30. So this is the transcript of the interview that the public protector has with Mr. Watson. And Chair, let me also place on record that this is not a complete reflection of the interview. There are a number of gaps in this transcript which has some materiality to the question, which we would then have to ask the public protector, and we may have to play part of the transcript because Mr. Watson switches between English and Xhosa, and the transcript doesn't reflect
trying to look at your bottle is in my way.
Doesn't reflect
Thank you.
what is stated in COSA on the transcript. But for the part that I'm using it for, it's go to 993, lines 25 to 30. I'll be on the right page. That's the interview with them. Try 939. Okay, there we go. Right. The public protector starts. Gavin Watson says the president has indicated that even the donor, and there's an inaudibility that they hosted several dinners and meetings across the country as a precursor to the CR17. Did you attend any of those? Yes, I attended some. How many? 2 or 3, says Gavin Watson. Okay, some. If I didn't, some of the directors did. Okay, some of the directors attended. Yeah. Okay. Besides the business relationship between Andile Ramaphosa with Blue Crane, any relationship you have with Ramaphosa family? No, says Gavin Watson. Gee, I'm not on the right page. I want to get to the page that deals with the transfer of the money. Let me just go down. Let's just see if we pick it up. Okay. Okay, well, maybe actually go up to the top, go up while we're on it. The public protector then was that the only instance where you had contract with Andile? And Watson responds, that's right. And it was made quite clear. The consultants, go down, with Andile was for Africa, not South Africa. It was made quite clear. No business was to be done in South Africa. So I've been to Uganda, I've been to Sierra Leone, I've been to Congo, looking for business opportunities, which he had a lot of contacts which were participating in various decision-making processes during that time for the various entities, okay? And then any other questions or any other information, I don't think there is one of your government contractors necessarily, because that one we asked from them and they were saying they told you that they don't expect anything, though they knew that AGO has some contracts with the state. Yes, but that was never even discussed, any South African contacts. Okay, so the allegation by Mr. Mkhwebane is that the transferring of money into Miyota was like creating or a suspicious transaction, because he's saying that the nature of the payment passing through several intermediaries does not accord with a straightforward donation and raises suspicion of money laundering. It's an allegation. Watson says it's absolute nonsense. So the PP says, so you don't agree with it? No, I definitely don't. Okay. Watson says about this public protector, the whole thing, everybody knew about it. It wasn't a clandestine thing. The leadership of the ANC knew about it. The top 6 knew about it, knew it was taking place. Nope, that's not the reference. Shipper, go down. Let me just see if I can find it. I'm looking for the reference. Maybe go up to 934. That's my other reference on my page. My apologies, Chair. Okay. Go back, go up. Okay, so Watson explains in the middle of the page at 10 that he was approached by the President's Committee that came to see me to participate in donating towards the campaign, which I did. He was approached by Mr. Mkhwebane. I think the name is spelled wrong. And then he says, okay, I don't like using people's names. He came and he asked me, I said, okay, fine. I spoke to my tax consultant, which had been working for me for quite some time, Piet Venter. I said to him, we need to transfer 500,000, okay, into the trust account that he gave me. In actual fact, that is what took place, very simple. I went to my secretary who does all my banking. I got her to transfer. In fact, transfer 3 million into that account, into Miyota account. Of that, 2.5 million was a separate business transaction, and the 500,000 went into the trust account. So the public protector asks, okay, so why did you transfer the money into Mioto instead of paying it on requesting your accountant to pay it directly into presumably EFG. And Watson says, that is what he suggested. That's why I called him in. Public protector says Venter. Watson says Venter, yes. Because they also do the audit. They audit our accounts as well. He is a tax consultant for the group and they audit our books. And they said that this would be the best way to do it, 2 separate entities, 2 separate transactions. So is Piet still employed by your company? No. When did he leave and the reasons for his departure? There was a bunch of allegations. Okay. There was a lot of irregularities which we picked up within the group itself. Okay, so we appointed new accounts. Okay, and there's still a whole investigation taking place into the group itself. So you don't remember when he left last year sometime. And so that explanation as to why it went between Watson to Mioto to EFG, I'm not able to find in the report. It may well be there in the evaluation of evidence, but I've not seen it. Mr. Watson further in this interview also says at lines 16 to 32 on one of the pages. Here's it. It goes further down. It's not the first time that he had actually transferred funds from his account into the Mioto account. He had done that before for other transactions. Okay, so I'm told these bank account details, so Shep was not moving. Okay. Right. So that's the end of the factual dispute that arises in respect of the alleged 1.2 billion and how it operated between the 2 accounts on a factual scenario to do that. Chair, I can do one section very quickly, finish now, and because I think some of it has been covered by Advocate Mkhwebane, and this relates to the improper relations and the president's knowledge of payments. And this goes to the duty to disclose donations in the CR17 campaign, which Advocate Mkhwebane covered, but the same evidence is linked into improper relations, disclosure of a donation and improper relations between the president and AGO. And that's why I'm going to it. And if you go to page 64, the Concord judgment. Out of 64. It's part of 64. And it's headed duty to disclose donations to CR17 campaign. And the court then says the public protector's findings under this headings are framed in confusing terms. The heading suggests that the report is dealing with the question whether the president exposed himself to any situation involving the risk of a conflict between his official duties and his private interest, or used his position to enrich himself and his son through businesses owned by African Global Operation. This heading is typed in bold letters and is done and this heading is typed in bold letters as is done with each heading under the section of the report setting out the findings. So the heading relates to the duty to disclose donations of the CR17 campaign. And then the court goes on. In 65. Then it says, surprisingly, this heading includes the issue whether the president used this position to enrich himself and his son through businesses owned by African Global Operations. It will be recalled that the written complaint merely stated that there was a probability of an improper relationship between the president and his family on one side and African Global Operations on the other. The issue of the president having enriched himself and his son was added by the public protector. On a reading of Section 4 of the Members Act, it is doubtful that the public protector may expand the scope of a complaint submitted to her with full particulars of the alleged conduct as prescribed by the section. Moreover, under the code, the prohibition against self-enrichment or improperly benefiting others is a self-standing prohibition that is separate from the one of exposing oneself to a conflict between official responsibilities and private interest. The essential elements of the latter prohibition are official responsibilities, private interest, the risk of a conflict between A and B, and a member's conduct that exposes him to that risk. The public protector makes sweeping findings which do not show how the president exposed himself to a situation involving the risk of a conflict between his official duties and private interest. It is difficult to appreciate how the breach of this prohibition was established without identifying the president's private business and his official responsibilities in respect of which he had exposed himself to a risk of conflict. And then they set out the relevant findings of the public protector's report, which we've already gone through it. In that basis, go to 69. We've been through these allegations already. The issue whether the president exposed himself to a situation involving the risk of a conflict is mentioned in the first subparagraph following the heading. The point made there is that the allegation that the president violated the code and the Members Act by exposing himself to the risk of a conflict or used his position to enrich himself and his son is substantiated. It will be recalled that here the public protector is recording her findings following an evaluation of the evidence. The form in which subparagraph 7.2.1 is framed suggests that the public protector was not sure upon which of the two grounds the allegation rested and was established. Otherwise, it makes no sense to say an allegation based on one or the other ground was substantiated. If both grounds were proved, the report would say so, or if only one was established, it would expressly say so, instead of saying one or the other. Notably, all the remaining subparagraphs are dedicated to the conclusion that the president breached the code by his failure to disclose donations made to the CR17 campaign. All of this had nothing to do with the heading that the president exposed himself to the risk of conflict or used his position to enrich himself and his son. Instead, these subparagraphs address the president's failure to disclose donations made to the CR17 campaign. It is not clear why this issue which was raised separately in the complaints, is treated as part of the issue contained in the relevant heading. But what is more concerning is the quality of the reasoning leading up to the various findings. For example, in subparagraph 7.2.2, the public protector reasoned that can be safely concluded that the campaign pledges towards the CR17 campaign was some form of sponsorship. And Advocate Mkhwebane took you through these paragraphs dealing with sponsorship. 71, 72, and she took you further into 81, 82, 83. No, okay, she says no, so let me go to 83, right? In the entire report, the public protector has not once referred, and Chair, if I'm incorrect that Advocate Mkhwebane did not cover it, then those are the relevant paragraphs that deals with that indicates that the president benefited personally from the CR17 campaign donations. The absence of such evidence was expressly raised in the representations made by the president in response to the interim report. And then the recordal of what is contained in the final report, the president had submitted. The recordal of what the president had submitted is in the final report. The Executive Ethics Code only requires members to disclose their own financial interest. The President never had any financial interest in the donations made to CR17. Money was donated to CR17. The President did not have any claim to the money or any say over it, with the exception of amounts he himself loaned to the campaign. He never received any of it. It thus remains CR17's money alone. And then 84 says, in rejecting this argument, the public protector did not refer to a single piece of evidence which showed that the President had in fact received money or personal benefit from the CR17 campaign. And then it details what she stated about the donations that had been received and the potential capture. And I'm pretty sure that Advocate Mkhwebane did go through the paragraphs in 1890 of the judgment, so I don't want to do it twice. But I do want to go to paragraph 110, which deals with this improper relationship between the President and African Global Operations, raising the suspicion of money laundering. And to point out that in the context of this, this was the paragraphs to which I referred when I did some of the intro relating to the application of PRECA and POCA, the two relevant legislations. And this is now under the heading of the improper relationship between the President and AGO. The public protector held in a report that the allegation made in the complaint of the leader of the official opposition had merit because it gave rise to this improper relationship because of the payment of 500,000 and because it gave rise to the suspicion of money laundering. And then it goes to what the evidence summarized in the public protector's own report indicates that neither the President nor his family participated in the transfer of that amount. The transfer was made by the employee of African Global Operations on the instructions of Watson. And then it describes how the transaction goes. And the last sentence goes, it is puzzling that despite the evidence placed before her, the public protector could conclude that the allegation had merit. And in 111, it appears that she disregarded all that evidence and reached the conclusion that was devoid of any factual foundation. The Constitution and relevant legislation require that the public protector must conduct proper investigations, rightly evaluate the evidence placed before her, and make findings which are supported by established facts. Here, the public protector's approach falls short of the standard, and I agree with the following observations of the High Court. And then they go to the High Court's allegations, which are set out in the judgment. And then in 112, the absence of facts is not the only defect. Public protector once again misconstrued the empowering legislation, and that is the whole issue about what is the ambit of Section 4 of the Act, and then the judgment goes into the application of what I called PRECA, the Prevention and Combating of Corrupt Activities Act, which we have already dealt with yesterday. And the court concludes at 116. With regard to the allegation that the President and his family were involved in illegal activities that gave rise to the suspicion of money laundering, the High Court held that the finding lacked legal and factual foundation, and that this conclusion is unassailable. Chair, we have two issues on CR17 that remains, which relates to the question of Audi and the issue of the remedial orders that was made that the public protector addressed you on. And then we'd like to touch on, we haven't done the complete exercise in the Gordhan matter in the same manner as yet, because we had prepared on CR17 first, given the statement had come out earlier, and I had put the application to you in anticipation. So we had just tampered a little bit with our initial plan on questioning to do the submission. But there are two aspects of the SARS unit matter that we would be in a position to take you through in respect of matters. what we do have is a table which shows the various allegations relating to the OIGI report that served before the High Court, which could be helpful for members because the court records are quite extensive. And we have a summary. Members would know that there are various reports referred to in the PP report relating to Minister Gordhan and the SARS unit. And the evidence was that the reference to other reports like the Sikakani report and the KPMG report were corroborative in nature. And so we've done the exercise to see which of the paragraphs of the Public Protector's report emanate almost verbatim or almost verbatim from those two reports. And so those are the two issues we would like to take you through. And I'm giving you a snapshot of it to say that we would like to be able to do that exercise tomorrow morning.
Okay, thank you. I think that snapshot help as you have given heads up, not only to us, even the PP itself has got heads up from what you've started doing, so that's helpful. We will continue therefore tomorrow and touch all of those areas.
Chair, I accept that had we been engaging in questioning the Public Protector, we would not have done it as expansively as we've done it now. We wouldn't have been afforded the time to do it. And we would have had to submit much of this in a written address, given that this evidence is before the committee. So following the instruction that was given to us yesterday, we're doing this exercise to assist the committee to get through some of the written evidence that is already serving before the committee.
Thank you. That's helpful. It's just 8 minutes to 5. Our time to end is 5. We will end it 8 minutes earlier. We're going to pause, colleagues, for an agenda meeting for the day and meet again tomorrow at 10 to continue. And then the areas have been highlighted already. Thank you. Meeting adjourned.